Lordship may please this matter. As regards item number 2 and 3, your Lordship may not like to take up this matter. Deeply obliged.
May it please your Lordship. With due consent of the other side, I beg to mention item number 59 of supplementary list. This matter may be taken up next week.
I beg to mention item number 60 of the supplementary list. I want to withdraw this petition with regard to matter.
What liberty?
My lord, earlier petitioner filed this under section 16 of this land law, my lord. Now, petitioners earlier filed this writ petition, my lord, section 16 of this 1956, my lord. Now, petitioner is appeared before this session court, my lord.
Liberty, I have to do that. Take it up the matter. See when the matter.
Yeah, please, your Lordship. I like to mention item number 34. The respondent filed a affidavit in opposition on 9th February. We require some time to file appropriate reply. Also, Your Honor, the Learned Counsel for the petitioner, Arts and Joy, is currently unavailable as this Ken matter has died.
Again on 18th of March 2000. Repeat that.
Right.
Wait, please, Lordship, I beg to mention item number 31 with the consent of the other side, my lord. In this matter, my lord, transfer petition has been filed in the apex court, my lord, for transfer of pending matters in other high courts as well as this insect matter.
Have you filed the transfer petition?
My lord, we have filed the petition.
What is the matter about?
My lord, it's about who is the appropriate government for fixation of minimum wages for workers of airlines and airports. The loaders and unloaders. Their contention, my lord, is that
Matter is pending.
sorry, my lord.
Matter is pending in the Supreme Court?
Yes, my lord. My lord, there's an order, my lord. I got the email.
No, it's okay. I've seen that order.
Ma-
Okay, the request for the Learned Counsel for the petition. Matter sent to John listed up to 6 weeks.
Deeply obliged. My lord, there was an
Daily list
interim
item
order. my lord.
28.
I'm sorry, my lord. There was an interim order.
Interim order, how can I extend an interim order? We are meeting at.
Ma-
I've not said anything about it.
My lord, in this case, my lord,
Item 28, personal appearance.
I have directed personal appearance of the Commissioner Secretary through video link, my lord.
Video link.
We personally present physically. And my lord,
Yes.
there is no Commissioner Secretary in the department. He is the Special Secretary of the department.
Yes.
And in the meantime, my lord, 61% payment has been released yesterday. It will be paid to the petitioner today. To the Treasury, it has been released. I have, to that effect, my lord, I have filed affidavit yesterday. Though, my lord, we filed it yesterday, I think copy has not been clapped with the record. All possible steps have been taken. The amount was due from 2 divisions, my lord. Not Lakhimpur and
Dhemaji and Silchar division.
Dhemaji and Silchar. For the Dhemaji division, my lord, we have released the amount yesterday. For Silchar division, my lord, we require some more time.
We
Right.
haven't received
They will
it now.
receive it today, my lord.
Only 16 lakhs out of 28 lakhs.
It will be
It
27
seems
lakhs.
16 lakhs is about to be released, sanctioned, and that too also the activity started after your lordship directed personal appearance.
No, it's okay. But then also, when are you paying the 28 lakhs?
But
The entire amount.
total amount will be not 28, it will be 27 lakhs, 43,000. On calculation, we could find it, madam. So out of which, my lord, 16 lakhs we have paid yesterday to the, it has been released to the treasury yesterday. It will be paid to the petitioner's account today, madam.
And the remaining?
Remaining, my lord, it is before the finance, we are pursuing it to the fullest possible extent, my lord. Some more time, my lord, we will release it, madam.
How much time?
At least a month time, my lord.
No,
because
no.
The formalities in the
Month?
finance department
No,
is too
because of
clumsy, my
month.
lord.
We have to revise the AF and revalidate the AF.
There is no
Understood.
apply for finance burden.
The secretary, the thing is like this. This was a due which was to be paid at that point of time when the matter was before that arbitration tribunal or whatever may be.
Facility.
That matter was there. At that point of time, you were supposed. And it is not understandable as to why the matter has been delayed. Now, I only appreciate one thing. If they come under the MSME, you have not challenged that award. If they come under the MSME, it is a statutory interest. Who is going to pay that interest? The state has to bear the burden of it on account of the delay in not making the payment. At the end of the day, it is the state which is going to, on one day or the other, has to pay. There's no. This is a case why I am asking you to pay the principal out here so that the interest can be stopped. Then there cannot be any interest on interest. That is the basic reason why I have directed for the payment of the principal. Now you have not done that. Thereby the interest is just accumulating.
3 times the bank rate.
It is a 21%.
Yes.
It is the state who has to bear the
Yes.
burden because you have not challenged the award. So under such circumstances, the only way out here is if you don't pay,
Release the
you
principal
have
and
to,
liability.
somebody has to bear it from their own expenses because the state exchequer can't be burdened out there. It is not that the PHE department doesn't have the money. It has the money. Recently, there has been a budget to whatever you get. You must have put this there. These orders have been passed long time back. So when these orders have been passed long time back, you must have made an accommodation out there in the budget. You should have asked the budgetary allocation for this amount. If you have not done that, then it is your fault.
But 3 weeks may be granted. Madam.
Not
We'll
three
do our
weeks
best.
business. You pay this amount, we'll see it on 4th
4th of
March.
March.
So let it be on 3rd or middle.
3rd is Sunday.
Before that, report from owner from, I may not be. Okay, my other colleague.
Anybody will else to be there. But we want the remaining amount to be paid by
4th of month.
Obliged.
May I give the details, my lord, figures, my lord, amount?
you have to given
Total
an
amount will be,
affidavit.
my lord, 27,43,623. And we have released, my lord, 16,83,240.
Where you have you mentioned in your
In the affidavit, no.
In the petition, we have not measured. We will do one thing, my lord, we'll file an affidavit. to that effect. In the affidavit that we have filed, my lord,
There also is not mentioned. It's even the affidavit is not mentioned.
we have indicated the amount released, my lord, in the affidavit. Last page of my affidavit, second last page. There's the fixation of ceiling. At the right hand column, my lord, page 81 of the affidavit.
but this is only 16 lakh.
Yeah, 16 lakh, my lord, we have released, it will be paid today. And remaining amount will be, my lord, 11 lakhs 97,000. Oh, sorry, 10 lakhs 60,490. That will try by 4th of March.
The secretary, your good name?
Tikanta Kumar Purva.
The Tikanta Kumar Purva, the learned secretary, the special secretary to the PHE department. Is present in person. Pursuant to the order passed by this court on 2/2/2024. During the course of the hearing, it was pointed out that the amount to which the petitioner is entitled to, the principal amount to which the petitioner is entitled is not 28 lakhs 80,804, but rather the amount is 27 lakh
43,623.
623. But how can you make it less?
On their calculation.
No, this calculation, that calculation is not material. The question is that there is an award.
There was an award for 20 lakh.
There is an award where you have duly accepted. You can't make it less.
From our calculation, because it remaining,
is,
also it will be very difficult to release.
There
now.
was a forum where you should have agitated that. You should have all along stated by way of an affidavit as to what was the exact amount. You have never stated that.
In fact, recently while calculating, my lord, we could find it.
Let them file an affidavit.
We'll file an affidavit, my lord,
Then we'll
in, supporting this step. Because at least,
Finally come to page, this affidavit which has been filed
my lord,
by
By him, he himself, my lord, he wants to know.
Albert respondent preliminary affidavit in opposition. There is no affidavit in opposition filed by you.
One, my
Denying
lord,
to
we
the
have
amount.
filed on 17/2/2022.
No, that is a preliminary affidavit.
Yes, ma'am.
But this award categorically makes it clear.
Yes.
The representative of AI is 28 lakh 28 lakh 67,845.
Yes, that MSME order, ma'am.
So you have to pay this amount. There's no other way.
My lord, difficulty is that, well, if we process that, well, that will be again rejected by finance.
Then in the 10th meeting, both the petitioners as well as the respondents were present. The representative of the PHE department see the additional affidavit filed by the petitioner
Yes, ma'am.
on
Page 7, ma'am.
23rd of January
Yes, I've seen, ma'am. Page
2023.
page 8, ma'am.
In the 10th meeting, the representative of the PHC department submitted a letter before the council wherein it stated that an amount of rupees 28 lakh 80,804 has remained as outstanding and informed the council that the earlier availability of the administrative approval has expired, and as such the division has already been instructed to submit the fresh
Yes, ma'am.
proposal to facilitate the submission of the funds. The council also, after hearing both the parties directed so and so, will make the payment within 1 month from the date of so and so.
True, my lord. But while now, my lord, issuing fresh administrative approval, it was find out to be 27 lakh. But if they now insist on 28, it will take further time because finance will be objecting. Is my lord, this is
No,
only on the.
finance cannot object on this. It is an award.
True, my
We
lord.
are in a case of an award.
True, my lord. But it is not an.
The writ petition is not dealing with the petitioner's actual liability vis-a-vis you. The
True, my lord.
liability which is being taken care of out here in this writ petition is the liability which has been given a reason out of the award. And that is why if I ask you to pay a little amount less and it, at a later amount something happens, then you can't apportion, which will again lead to interest upon interest.
So this is the final calculation that we have made. That's why, my lord.
No,
Because
if you have not can you now?
we have not challenged that order, my lord.
So as of now, this is an order passed by an authority,
True, my lord.
which is final, as it has not been challenged. So under such circumstances, this is the amount. Whether the finance approved or not, that is none of my business out there.
So let
The
us now
fact
pay
is,
the actual amount that we have. Because
you
my-
have
I
to
will
take it
also-
up. Just for example, tomorrow a decree has been passed
My lord,
by a court.
I understand, madam.
Now, once the decree has been passed, may not be the amount exactly, rightly or wrongly, there is an order being passed. Unless that is not challenged in a
I
court of
understand.
law and not set aside, that is the amount which is final.
I
And for
understand.
that, whether the finance gives or not, we are not concerned with that. The PHE department has to make the payment.
I understand, madam. It is with humble, my lord, respect, my lord. This is also a writ petition, my lord, not for execution of the award. So that's why, my lord, we are giving the actual figure, my lord, it is 27 lakh. Let us pay that, my lord, remaining if anything, because it is not being concluded. Writ petition is still pending, my lord. They can also hesitate, we can also find. Let us pay 720. That will be easier for us, my lord. Because otherwise, my lord, things will become complicated. Because beyond records, we have to make payment, my lord. It will be difficult.
There is no record.
I
This is an
understand, my lord.
award. It is an award.
They are entitled for 27 lakh, my lord, on as per our record, my lord. So if now we
You have not filed an affidavit.
We
Neither
file-
you have stated in your
we
affidavit,
file
additional
affidavit,
affidavit.
sir.
No, you have not done that. If you have not done that, why should you this court consider it to be less? This court has specifically directed you to pay 28 lakhs, 80,080. How you take the option, the finance concurrence or not, that is immaterial. Let us have a finance council somewhere. Where is Mr. Arbor Pujari or anybody? Get on.
When is the party again? I think the part of the party there. মই তো এইখিনি মোক কৰিব পাৰা মোৰ বাকীবোৰ কি হ'ব You tell the court to make the effort to pay. If you can pay it. I'll make a deal with other cases. If it is token active. It's time. It looks not yet content now. It looks not. You have equal from half the answer to top. If it is something, it is valid text. Now, it is not. It is still, let's see. No, agree no full. It is. You not.
The administrative approval that was earlier issued, well, that time not issued. Now we have to rebuild it, the same amount will be insisted. That's the thing. I understand, my lord, our person has admitted, my lord.
No. That is not the question. The question is the amount which have been awarded
Yes,
is
my lord.
28 lakh. How
Yes.
can this court
Unless
now,
it is
no,
10 cell or
the
7 cell.
moment I reduce it,
I
couldn't
understand,
this court be sitting over that award which has
Agree.
not been
changing the
challenged?
mandate. I understand.
So this court has no other option but
So-
to hold it that it is 28 lakh. You have to pay that.
May I pray one thing, my lord? Instead of, my lord, indicating the amount today, my lord may indicate this has been paid, remaining will be paid. In the meantime, let us see what we can.
You have to take it. The present to and to. During the no, no, hetu nahi. During the course of hearing, it was brought to the attention of this court that an additional affidavit has been filed by the principal secretary or by the special secretary to the government of Assam PHE department on from the said affidavit, it reveals that out of the amount of rupees 28,80,804 as directed to be paid, an amount of rupees 16,83,214 have already been sanctioned and sent to the
Treasury.
and appropriate directions have been issued to the treasury to release disburse the said amount to the petitioner. The learned the special secretary who is present during the course of the hearing had further stated that the remaining amount would be paid on or before 4th of March 2024. List the matter again on 6th of March 2024 for an appraisal, for an update. The personal appearance of Mr. So, the learned special secretary to the government of Assam PHE department is hence dispensed with.
Briefly open.
Mr. Special Secretary, kindly appreciate one thing. If you don't pay the amount, I'm not concerned. The interest will keep on accumulating. And if the interest accumulates,
Yes.
one day or other, you have to pay. There's no way. But if you have to pay, the problem will be how do you take care of that? Will keep on accumulating.
In fact, in this department,
In
my
fact, when I pass the first order, my basic intention is that you pay the principal, then let them fight out as regards the interest before before whatever executing court they can very well go for that. But the principal has to be so that there is a stoppage to the interest. But it seems nothing has been done.
Lordship, there are number of matters where the principal has not been paid.
in PHC department, my learned senior knows, my lord, against 10 crore of principal amount, clients of my learned senior for 100 crores.
And that's not
There's a
my
PIU
fault.
inquiry pending.
That's not my fault.
there's
The
no,
inquiry is over. That's not my fault.
That is,
No, I'm not
on
saying it
basis
is
of
fault.
award.
It is because of the apathy of the department, my lord. Please have that.
So why
It
should
is
I
not
be
the apathy
victimized?
of the department, it is the department allotting works without having money. That's the main problem.
And Lordship,
They should not.
like that.
And
Like
why?
as you are now doing, you are taking over land, acquiring lands without having money.
Absolutely.
Yes.
This is the big problem which is being daily faced by.
And like lordship chosen few
That
days.
day I found a matter which was to be paid 56,000 acquisition amount. 56,000. You know now how much it has become? 49 lakhs. And that to 49 lakhs it is not going to be. Now it will be around 4 crore.
So it's nothing surprising.
This is the state of affairs.
How like?
No, 57.
Yes, we have filed the affidavit.
Yes, your lordship. And
We
paper,
can reserve it.
yes, sir. Lordship, the paper.
You have to say anything.
Just for the, actually, we have deducted the amount and paid it to the state government. Now, the fund is required to be given, the state government will give. And so far as the service tax component is concerned, my lord, the railway has borne the liability. Service tax component, my lord, we have reimbursed to the particular. Although they have paid, we have reimbursed.
You have now to again pay back. No, service tax. We are not concerned with that.
Concern, not concern.
Whatever you do, you do. Here, the only challenge is limited as to whether it is a amount to this. And have you filed the affidavit?
And it's already on record.
Hearing completed, judgment.
That much. On top of that, now there is no relief claim against.
Huh?
There is no relief claim against after.
Don't worry. This court knows how to mold the relief and give it against.
Obliged.
I don't know what permission.
Lordship, in this matters, we have filed the affidavit, but that is not on record. Lordship, may take it up at 2 in the meantime that the affidavit can be called for.
For that one,
That one, your Lordship, with regard to payment for SIM swapping from the bank.
we'll have it in the next. We'll have it next week after I come back.
I have already filed. I have given annexed to specifically the RBI guidelines in those, and that specifically states that I am entitled. So that is important.
No, you are entitled, but from whom?
It is from the SB. There are 2 affidavits filed by me. One against SIM swapping. In the SIM swapping case, specifically the guidelines of Government of India, Department of Telecommunication has stated that these are the guidelines under which you can do the SIM swapping on. That has not been followed. I have that their liabilities. Secondly, the RBI guidelines of 2017 specifically indicates that in such a situation, when it is neither the fault of the bank, neither the fault of the person concerned, the customer, in that case, what will be the liability of the customer as well as the bank? That is there. There, your lordship, my liability is up to the point of 10,000.
10?
10,000. Whichever is lower. So here it is an amount of about 8 lakhs plus. So 10,000 deducted. That part, that is why that is important, your
But
lordship.
once they have done it on the basis of a swapping which had happened on account of a call
Yes.
made by the Airtel, and this was duly done, how can you?
They have given that there is a zero liability of the customer if it is done, if the information is given within 3 days. But if information is given within 7 days, in this case it is 5 days, then my liability is only up to 10. Rest of the amount, and they have to reverse the amount to my account within 90 days. If there is any dispute, that disputes they have to prove that it is, they have to prove that the burden of proof is on them to show. Here, your lordship, already police has disclosed that I am not in fault because I have not disclosed the UPI PIN, which they have alleged. That is not done. So their liability is not there. Our liability is also not there. But as per the RBI guidelines, I am entitled to the. That is why, your lordship, that I have annexed those in the affidavit.
New affidavit. When did you file?
Yesterday, your lordship.
It has not come up.
Not on record. That's why I am praying, your lordship.
Lordship, last occasion directed me to take
Yes,
instruction
I've
as
asked
whether-
you.
Yes,
So
my lord.
where is the money?
My lord, Canara Bank account, my lord, lordship wanted to do the money
lying in Canara Bank account, that is for 19,107 rupees.
90,000.
19,000 remain in the account, my lord, of Canara Bank.
What happened? Remaining?
That is it now, my lord.
And what about the SBI who doesn't have that amount?
Lordship directed me to take instruction on Canara Bank.
Direct the superintendent to appraise this report on the next day as to whether the money which has been transferred to the account of the arrested person held in Canara
Canara.
Bank is still lying in the bank account of the arrested accused person.
Now lying, my lord, 19,107 rupees now.
So that means these people have already taken it,
Second,
and those persons are not parties here.
Lord,
Anyway, let me
Let
let
the affidavit
instruction.
come. here.
Mr. Y.S. Manan, the learned counsel appearing on behalf of the submits that their two affidavits have been filed yesterday. However, those affidavits are not a part of the report. It has also been duly submitted that from the two affidavits, the two affidavits pertain to in the two affidavits, the petitioner have enclosed an RBI circular as well as also the circular issued by the government of India
India, Department of
in
Tele,
respect to seems quite
that is with regard to CP,
swapping.
swapping.
The respondent, that is the State Bank of India, as well as the Airtel, who have already served copies of the state. You have got that affidavit of team swapping. No,
That I-
for the RBI. Have you got that government of India team swapping?
No,
I-
I have given that affidavit which he is a respondent 11 and 9, 10 and 11. That he has got the affidavit and he has got the affidavit for 9. If they are required to be given the affidavit of the other, I am giving.
The learned counsel who appearing on behalf of the respondent State Bank of India as well as the Airtel
Actually, roll
shall
he didn't copy it. Actually.
to be at liberty to file their reply to the state affidavit if so advised. List the matter again on 7th of March 2024 for further consideration.
Much obliged.
It has also been brought to the attention of this court by Ms. Yuda, the learned additional senior government application, that the amount lying in the account of the arrested person in the Canara Bank is rupees 19,000.
107.62.
Four. 3 years. Yes, what is this?
Lordship, I entered into an agreement
Wait,
with the
Wait.
page, it starts from 14 euros in 2499 euros.
with whom?
2499 of the 15. And there are other agreements also on date of the original person with whom the agreement was made, owner of the tea garden, your lordship. Salisbury Tea Estate, your lordship. That is the tea garden. So I was running the affairs of the tea garden, your lordship, after taking a lease from the original owner of the tea
You have
garden, your lordship.
taken a here from one Mohammed
Yes, Lord.
Audullah.
Yes, Lord.
Okay. Then Ayat Audullah. These for what?
For lease of
20
the tea
because of
garden, your
land.
lordship.
Then what happened?
Then the person died, and thereafter another agreement was made, your lordship.
Then
That agreement is still subsist, your lordship.
Then
And then what happened, your lordship? Suddenly, I was running the affairs of the tea garden, your lordship, peacefully, but then suddenly the Apex Bank officials visited the tea garden and wanted to take possession of the tea garden, your lordship. And they have issued a surfacing notice also, your lordship, 32, the surface jail. But,
can you file a FIR?
and they filed an FIR that I resisted taking over possession of the tea garden by the bank, your lordship.
Then
And after that, you can anticipatory bail, your lordship, and thereafter, your lordship, they have issued this surfacing notice, your lordship. And after that, I filed this, your lordship, this writ petition, your lordship. And in this writ petition, your lordship, status quo order was granted, your lordship, by the honorable court.
then who is paying for Apex Bank?
Mr. Goswami was paying, your lordship. But then there is an issue, your lordship, in this respect, your lordship. There is a case pending before the honorable apex court as to whether tea garden land is agricultural land or not, your lordship. If the tea garden land is declared to be agricultural land, your lordship, SARFAESI will not, DRT, SARFAESI Act will not apply, your lordship. And that is still pending before the apex court, your lordship. Therefore, this matter is to be kept in abeyance, your lordship, until the judgment of the apex court comes, your lordship. But then thereafter, your lordship may take up this 7733, your lordship.
That what
Then
why the second writ petition?
second petition is because, your lordship, after the agreement with the original owner of the tea garden, your lordship, I obtained permission for operating a brick kiln, your lordship.
On
In
that
a
land,
vacant land, of the
You
tea
have-
garden,
taken a permission for brick.
not from the authority, your lordship.
Then?
That was granted, your lordship. Permission was given to me for operating establishing a brick kiln, your lordship. And that I was running the brick kiln, lordship. And that portion of the land, your lordship, that has been declassified, your lordship, from the tea garden land, your lordship, as non-agricultural land, your lordship. And thereafter, your lordship,
So where is the Apex Bank council? Where is Apex Bank? Where is Mr. PN Sami or Chico Boy for the Apex Bank? Now tell me, if this is the area which has become now big, how do you bring in section 31 of the surface?
not in respect of that, your lordship.
This is a different land.
This is a different,
Then why I put my matters text there?
because it pertains to the same tea garden, your lordship. Only a separate land is, some portion is declassified as non-agricultural land. That is why in that particular,
But is it a part of the same lease deed?
it is the same tea garden, your lordship.
Is it a part of the same lease deed? Where it has in the
Yes,
lease
yes, lordship.
deed,
Yes, that
where
is
is
it.
your lease deed? Let us see.
That is a part of the same lease deed, your lordship.
Where is the lease deed?
In 7733, your lordship may come to page 17.
Only 20 because of that. And this lease deed is over or no?
Lordship.
Area of 20 acres of land
Yes, sir.
covered by dark number 10 acres and 20 acres.
Page
periodic
25 schedule
patta.
is given, your lordship.
Then where is the other leave? For any other land?
Lordship,
Now, once it has been
lordship will
declassified,
come to page 25. That is the schedule of the land. your
I've
lordship.
seen it. This is being shown as T periodic land. A T periodic patta number 1 of type 12. So it is a T land.
That has been declassified, your
So
lordship.
now, if it has been declassified, how does section 31 come into play?
That in this respect, there is no question of
No. If that is why both the courts have connected it. You say that section 31 comes into play because the security interest created on agricultural land in terms of section 31C of the Surface Act cannot be, the act would not apply. Okay. Now, if that very land has been declassified, then how can there be a security interest on the agricultural land? That is why both the matters are tagged.
We have filed the affidavit, my lord. The state of my lord, it's not reclassified. Still, my lord, T periodic patta land.
A proposal was sent by lordship, your lordship.
It's not much because government has, there is an act also, my
No, I know that.
lord,
You see, T periodic patta, you can't make this in this manner.
lordship.
You have to not only make it clear from here, you also have to change it out there in the T board.
Lordship.
Every land out there in the T board,
Lordship.
specifically put out there.
Act of 15, my lord, 2015, my lord. It's clear.
So what is wrong with this order? And what is this contempt?
Contempt is your lordship. There is a stay order granted in another case, your lordship, 6730 of
Where? Where is the order?
that is at page 56, your lordship. In 7733.
No, no, page 28.
At page
Violation
56.
of what order?
56, your lordship. That is the order passed by this honorable court in 673015, your lord.
What is that order?
That is at 7733, your lordship. It is also here, your lordship. In the content also it is there, your lordship, at page 28.
You submitted your reply.
I submitted my reply, your lordship.
And then
They have not taken any action, your lordship. And
Then why, if there is no, they have
suddenly,
not
your
taken any
lordship,
action, then why are you, have you filed the contempt?
because there is an order passed by the authorities, your lordship, to vacate the land, your lordship. That is at page 29, 32, your lordship. Without taking any,
This very order you have challenged in which 7733.
no, I have not
Have you
challenged this
challenged
one.
this order? No.
No, this is this is in content only, your lordship. And I have also challenged it in there is another writ petition, your lordship, 5234 of 19.
Where is it? Pending?
This is pending.
What is the number?
5234
Of?
19.
There's another petition. Yes,
Yes, your
I have
lordship.
found it. Yes, 522. What is that? That is challenging 47/2019.
That is also there, but then your lordship, there is another order passed by this by the authorities for cancellation for closure of the brick failure. That is 472019, your lordship.
Now, this is what you are challenging 47/2019,
Yes.
for which you have done this contempt.
Yeah.
Yes, Mr. Corputari. Come here. Okay. Now, yeah. What is this thing? How do you permit the change of periodic patta and declassify patta or declassify?
There is an order, your lordship, of the authorities that
No, authority, how, can
agriculture department has,
anybody do this matter? What is
agriculture department has issued an order, your lordship.
aspect deputy after declare?
My lordship is putting in query to, in respect of T periodic patta.
Ah,
Now T periodic patta, there is a hole. There is a hole.
no,
So-
there cannot be a change of the nomenclature from
Yes.
periodic patta to normal unless the deputy commissioner gets the approval from the government.
One
And
concept-
that these are notifications in the year 1990 or 91, there are notifications.
And in 2006 also there is a notification. In fact, one content is also might have listed before lordship today with regard to that same subject matter.
This is the matter which is there here. Now there is, what has happened? Now what has happened here is this. The petitioner here, out here, the sorry state of affairs is the Apex Bank is not represented. The petitioner herein, you are Apex Bank. Then why you are not representing? What has happened here? Petitioner takes the lead of a periodic. After taking on lead the periodic patta, action is taken by Apex Bank under the surface. He comes up with a plea, the 31G of surface, agricultural land interest created on agricultural land cannot be taken. The matter is pending in the. But on the other hand, now what he does, he gets the land declassified. And once it is being declassified, he runs a what you call a brick claim. Now, if it is a brick claim and got it declassified, whether 31G will come in? No.
No.
Now, the question is, can there be a change of under 31? Can a periodic patta be just changed in this manner?
No.
If
Yeah,
it cannot be done,
Yes, there are executive instructions and notifications issued by the revenue department. So far as secretive. Now, my lord, now, my lord, the legislature is proposing, my lord, of course, that is on the anvil, my that some amendments might be there. Because I am, my lord, speaking of the contempt case, my lord, item number 50. This is not that item. Item number 50, same subject matter. Same. So this honorable court, my lord, directed, directed the deputy commissioner to grant self permission. There was a periodic patta land. It is, my lord, in the district of Dibrugarh, in the heart of Dibrugarh town. It is
Jalannagar.
Jalannagar is the heart. Now that the petitioner, he entered into an agreement with a builder and, my lord, development agreement, and flats have been sold out. They constructed the building to some extent, my lord. Now the sale permission has been held up. To that extent, my lord, we filed a writ petition. In the writ petition, the honorable single judge directed the deputy commissioner to do the needful in terms of government circulars and issue, my lord, permission. Now the deputy commissioner has done it. Now there was no direction to the government per se. Now the matter is pending before the government, and because of this bottleneck, my lord, it is hanging. That is item number 50. I will be appearing, my lord, in that matter. Same issue,
Therefore, because I know both notifications are there,
Yes,
whereby you cannot transfer or remove or,
Yes,
or
yes.
change the
Yes.
without getting it permission from there.
yes. In fact, there are, my lord, direct statute on the point. There were Reassessment Act and Reclassification Act.
Yes.
These are the two acts governing the field.
And apart from that, once the objection is mainly put by people,
Yes,
because whenever a land is taken out there, the people puts it in their marks, and these tea garden lands are very well put out there.
yes,
So they put the objection, how do you change it?
yes. Because it is for that reason, my lord, in the 1956 Tilling Act also, my lord, there is no tilling limit for the purpose of, my lord, the garden area. It's only with regard to ancillary purpose that there is a fixation of tilling limit. Garden area, it may extend, my lord. unlimited, infinite, my lord.
No, that is
Therefore-
why it doesn't apply.
That is why it
PPC
does,
tax does not apply.
yes. So therefore, my lord, it is not that easy, my lord, at one stroke, my lord, we can change the classification of the net, my lord. There are standing circulars. In fact, in that contempt application, lordship will find it,
That is,
my lord.
yes, effect. Effect bank is very difficult to find. One has to keep on searching this. You know the fact or not? Or you have been able to gather the fact of what I have taken.
Here in this case, today I got the file, Lordship, but at the same time, Lordship, regarding the whether the apex bank, the question whether the apex bank is within the purview of the banking regulatory act, Lordship, there is a notification. We are within that.
We are not concerned on that. Each issue is different. Each issue is in view of 31C of the Courtesy Act. An interest created on agricultural land cannot be a subject matter of a proceedings under the serviceable.
Regarding tea garden, Lordship, it is not the agricultural land in other words, it is the tea periodic patta is there, Lordship. PF patta is there. So therefore, it will not come under the agriculture.
That matter is pending before the apex court,
Yes.
your lordship, for decision.
Yes, that is subsidized, pending before the apex court.
Then
I have your lordship.
what have you taken? Are you now going under the TRT against that?
Regarding DRT, Lordship,
You know or don't know anything?
Lordship, I
If
have
you don't know anything, don't make it. I make it big. You know anything, any head or tail about the map?
Lordship, I have to go through it.
Matter upon being taken up, the Senate Council appearing on behalf of the tax bank. If they are aware about the should have been paid, taking into account above, this matter stands adjourned, it is still again on 11th March, on which date it is expected that the effect for after for the effect for prepared to place for the court as better. And if you are stated again, the default is the defaulter who under whom the petition claim.
Lordship, in 2499, there is a status quo order, your lordship.
Yes, what is it?
There is status quo order subsisting, your lordship. Oblige.
In this case, the matter has been structured. Of the list.
May I please your lordship? Lordship, I'm appearing on behalf of Miss D. Ghosh, lordship. And
Appearing on behalf of,
Miss D. Ghosh, lordship, my
Okay.
senior.
tell me,
Yes,
yes,
lordship.
health and family.
My lord, so
Is
far
the
as the
fact of
treatment is concerned, well, it was the main issue. That has already been provided to the petitioner pursuant to the interim order passed on 11/5/2017.
What,
Free treatment, my lord.
the petitioner was suffering from choriocarcinoma, lordship, and she was provided with the
your
treatment.
direction to the to facilitate the treatment of the petitioner, including treatment of all diabetes and medicine free of which the reimbursement of that. Yes, what has happened?
Well, that treatment has already been given and pursuant to the undertaking given by before the honorable court.
They have already given that.
Yes,
So you are well now.
Lordship, as per the telephonic conversation with the petitioner Lordship, she is still suffering from pain, and while walking, she is still suffering from pain. And we have suggested her to go by Monday to the hospital and give the proper report, Lordship, because this
What
kind
were
of
you suffering from?
choriocarcinoma, Lordship. It's
What
a
is that?
uterus cancer.
So then,
So,
so let her,
chemotherapy.
have she applied as per this
Yes,
Ayushman
Lordship.
Bharat?
Yes, Lordship.
When?
She got chemotherapy also, Lordship.
Oh, Ayushman Bharat, they give these 5 lakh.
Yes,
Then
Lordship.
you're getting it.
But she has not received, Lordship.
No. You don't get the money. You have a Ayushman Bharat.
Yes, Lordship.
If you have the card, they give these authorities, all hospitals get free of it for 5 lakh.
Yes,
Why do
Lordship.
you
But
need it?
she was denied for this thing, Lordship. As
That
per
is not the
telephone
subject matter before
conversation.
this court.
Yes, Lordship.
Sir, this has already been given now. If you are achieved by anything, very well, then take it up.
And
with
you
the
have to apply,
authorities
madam.
concerned.
For that, you have to apply.
Yeah.
Already applied, Lordship.
Is it Atal Amrit Abhijan is a different spectrum. And
Yes.
now you have the Ayushman Bharat.
Yes, Lordship.
Ayushman Bharat provides 5 lakh, isn't it? You
But-
come within the ambit of this Ayushman Bharat or not?
Yes, Lordship.
You come out of that, you apply out there. You don't get it matter, then the question will arise, which is a different thing. But everybody, you have the card.
Yes, Lordship.
Yes,
Atal,
matter.
she has only
Yeah.
Atal
The instant
Amrit
the petition has
Abhiyan
been
card,
filed,
Lordship.
taking a direction of the responses to facilitate the provision of diagnostic facilities and medicine free of charge. It has been submitted by the COCO, the learning council appearing on behalf of the health and family welfare department. That in pursuant to the order passed by the court on 11/5/2017, the petitioner have already provided the state benefit. The learning council appearing on behalf of the petitioner, however, submit that the petitioner still continues to suffer on account of the disease. However, this court had put a specific query for the learning council appearing on behalf of the petitioner as to whether the petitioner comes within the ambit, is a beneficiary of the Ayushman Bharat scheme. The learning council submits, for the petitioner has submitted that the petitioner is a beneficiary and have also been provided a card.
She has only Atal.
Ayushman Bharat.
No, Lordship.
Then why you are not applying?
She has
This
to
is a new
apply,
scheme.
Lordship.
Why with the learning council as to whether the petitioner is a beneficiary under the Government of India scheme. The Government of India?
Yes, Lord.
The Government of India scheme, that is Ayushman Bharat. The learning council for the petitioner submits that he has no instructions with that regard. However, if taking into account about the court of the opinion that the petitioner wants to avail any benefit, the petitioner would be at liberty to claim the benefits under the Ayushman Bharat scheme subject to the petitioner falling within the eligibility. In that case of the matter, nothing further remains to be decided in the
Much.
Yes, what it is?
My lord, my land was encroached by the municipality. DC came and asked us to demolish my eastern portion of boundary. I resisted, but they did not obey. Then we filed this writ petition and we have been provided interim relief. They have not filed affidavit till today.
Who is it? Who wants to take it?
The main party is the
Delegation is taken.
municipal board, Kazalgaon Municipal Board.
You have done it?
But after the bifurcation of the district, my lord, now the full-fledged municipality has come into existence. So we are in a difficult position to contact with those officials, my lord, because they are no more in the committee. Now the municipality has come up. So some more time may be given so that, they can trace out those documents. After the bifurcation of the district, and the Chirang district has been constituted. And there is now this Kajalka committee and chairman Kajalka will no more exist.
No, Chirang district was there at that time also. But now it is converted, upgraded onto municipality.
We dispose it. Don't do anything without. The instant petition has been filed by the taking appropriate directions against the respondent. Not in terms of them, taking it for the criminal conflict one. Age, etc. Standing on the patha land of the or construct any drain in the patha land of the without the procedure established by law. The record reveals that the petitioner claims to be the owner of the landholder and possessor of the land, that is 0.3 letter and 0.9.5 percent, situated at Village Kukumari, Yes, Halika, Muda, Tipri, Part Roman 2, Public, Bongaigaon, Gaon or Bongaigaon,
Bongaigaon.
Bongaigaon, in the district of Chirang.
Now at Kajalka.
The said that is covered by tag number 81 and included in chapter number 4.
Para 4.
The court finds it relevant to observe that although the petitioner claims the land to have been purchased on the basis of a sale during the of the 1299, however, the state deed of sale is not a part of the incident.
No, through additional affidavit is filed by law. On 12 June 2017, additional affidavit is there.
Where
It may be filed. On 12 June, you have filed.
there is only one. Why should this court take into consideration these documents when you have not given the entire document in translated form?
No, it is provided. Can you see that?
No, it is not there. Yeah, not included.
No, this
Yeah,
is
it
there.
is
So it is High Court seal is there, madam.
1990.
Office seal is there.
So, this court, however, finds it that there is some conclusion that that the affidavit has been filed where the petitioner claims that the same pertains to the very the petitioner claims that that those documents include very relates to the deeds of sale. However, the translated copy of the state document that we page does not clearly repeat the same. Treated as it may, it's a thing that the respondent or particular the respondent number 5 and 6 4, 5 and 6 without following the due procedure have tried to encroach upon the petitioner's act and thereupon they abolish the eastern part of the petitioner's certificate of the court at the gate etc. covering it into 100 approximately or as well as intended to act it is intended to construct a drain in the state Pata land. It is under such circumstances the petitioner has to approach the court by filing their instant. The record reveals that this court, by the order date 12/6/2017, issued notice and the inquiry directed that no public drain shall be constructed by the respondent or protected the response of private take over a parcel portion of the private land of thereupon the matter have been listed on various occasions, but the respondents have not filed the application. On its court activity heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the Mr. Yes, what's your name?
As this was.
S. Vishwakarma, the learned counsel appearing on behalf of the response of 5 and 6 and the S.R. Guru appearing on behalf of the 1, 2, 4. The issue involved with the instant things where Jupiter could have a care without following the due process. Take over the private land of the petition and demolish the structure as well as construct a private public drain on the land. The same aspect is clear from a reading of the Article 200A of the Constitution, which stipulates that no person shall be deprived of the property saved by authority law. Under such circumstances, if the property on which the petitioner is claiming right is the property of the respondent authority, the opinion of the court cannot disturb the possession of the petitioner without following the due procedure. According this court therefore disposing of the instant thereby directing the respondent authority not to disturb the possession of the over the land wherein the petitioner has right over the land the petitioner has right that is in without following the due law. whether that report directs the said respondent that in that circumstance, any steps are to be taken on the land of the petitioner has been noticed, thereby permitting the petitioner to submit necessary documents claiming, showing that he has rights to the land. The above the instance that
My name may be corrected as Biswas.
as and appears on behalf of the petitioner or court. It is seen that on the earlier occasion also the petitioner was not present. Considering the above, the in name already given. Report 12 to 14. Yep. What are these matters, man?
These are relating to search and seizure, Lordship. Search and seizure, Lordship, this was at a time when the GST was at a nascent stage. Lordship, 1/7/2017, the GST Act had come into being, and this search and seizure was made on our company on 28th of Lordship July, within 27 days of coming into effect of GST. Lordship, the order dated 16th of August, Lordship, this passed by this honorable court.
16th?
Of August, 16/8/2017.
Good.
Lordship, the entire thing is very clearly mentioned over there.
It was the search conducted.
Lordship, on 28th of July, 28th of July 2017.
8/7, 28,
17, Lordship.
So after 1/7, it has come.
After 1/7. Lordship, after coming into effect of GST, and BIO had no power at that point of time. They were not given the power.
Yes. What happened?
We have filed our affidavit, Lordship.
What do you say?
In our affidavit, we have said that some information has get by the authority, and after that, this says the items, it will not, etc. And if it is
Now, is
found,
there a ban on transportation of what you call or import of vanilla?
yes,
They are banned.
Yes, these are smuggled goods.
smuggle goods.
That's the final matter.
Then if it is smuggled, what is that? Well,
I am appealed for a tax approach.
understood. What business
Teaser has
you
been
have?
made by the PIO.
BIO has faced the.
Understood. PIO, what authority they have? If it is a case of smuggle, then the customs have been there.
A case also registered. a case also registered, PS case number 90/2000.
Then?
Then the maps were sent for testing, and when to Karnataka, sent for some testing, and the test report has said that these are foreign
That?
or Indonesian origin.
smuggled.
Smuggled, yes.
Now, if you the smuggle good, does the tax authority have any?
That is the FDN, because they are not been able to get any document to prove the genuineness of particular food that is being from their product. And I got the sample of the Rekata, it is that now the report says that there are that's what the food. That's the food.
So if it is Indonesia, can there be an ethnic?
No, it's not that matter. So far as the PIO is concerned, madam, they are
PIO we took it.
No,
First, if it is the fact that it's a Indonesian origin, that it is liable for paper tax.
not that matter. In the group pilot or the team who went to seize the document, good pilot, a official of the tax department was there. It is always there in BIO, in the office of the BIO, from income tax, from taxing authorities, everyone is there. So in that context, my lord, he has been made a party in the present. Not that
No.
there's some
Why
demand
I'm
of it.
saying it, there's a direct of payment of petty taxes back there as a part of a tax.
Lot.
Now, where the picture of the payment of tax back guarantee if the
Case of my lord, and I did it that day I got that prepared. But if that at least 2-3 days, my lord, next week, this week, because goods have probably been released.
would have been released.
The only thing
And
remains
you
that
have
part.
kept the bank guarantee only on the basis that 30 tax bank guarantee.
Yes, Your
Fine.
Lordship.
In all the cases.
In all the, it is a group of cases, all the three cases, Lordship, total 30 lakhs bank guarantee we have given.
And each
Total,
The total is
total, because there were 7,290 packs. So we paid the tax on the same. Lordship, the BIA authorities has not even released my 7,290 packs. They have released only 6,000 something bags. The other bags, they are saying that we don't know where it is. It has been stolen.
these are
That is
not on
also
record.
that is also on record, Lordship. They have not released my 7,290 bags they have seized. That is also there.
if you have filed
Lordship, I have filed a Lordship a criminal complaint against them, but Lordship, and they have filed that Lordship that PS case number what they are referring to, they have filed to themselves. BIO has filed a case to BIO itself. So BIO is investigating my case, criminal case, and we have filed a case against them in the police station. They have filed the case in their police BIO itself.
No, therefore, if now find that yes, he is smuggled, then there cannot be a tax.
Pardon?
There cannot be a sales tax or a GST. It may
Yes, smuggled.
it would amount to a custom.
That case, my lord, yes, that will be one of the items to do.
And therefore, it was the submission of Mr. Kyle then that the PIO did so without informing the customs.
Rashid, they are not sure why they have done, because in the Caesar list they are saying that we have done evasion of tax. Thereafter, every day they are coming up with new stories. Rashid, I'll place whenever the matter will be there. Every day they have come up with a new story relating to this case. Lordship, not next week, Lordship. If it can be, Lordship, in the second week of March.
If you want it, you will be prepared.
Yes.
Anytime I know that case.
Adam is
They
always
can be- But there, when as per their I will be there. Any day of the second week of the March.
this matter again. 13th of March.
Lordship, 18th or 19th? 18, 19, any day on this during that week.
18th.
Yes, sir.
Matters that they adjourn. 18th of March, due to the fact that none has appeared up Customs Department Customs of the government. The name of Mr. Architect is the Customs Department, the Customs, who is there?
Okay, Mr. Okay.
Yeah.
RKD Chaudhary will be
The name of Mr. Architect, we don't need to post it, the next.
Lordship, I think so for custom department, Mr. B.N. Gogoi is there. Specifically for the customs department, Mr. B.N. Gogoi. I'll inform him also, he will also be there. Custom department.
The rate, yeah. It's submitted as a part that the PN proposed the rate.
Customs
Much
is not party.
It's a party. Yes, your lordship, Union of India is a party.
Therefore, the earlier order was better. Yes.
Item number 6.
The Union of India, and in their app, that's the the architect of the
Mr. Lordship, we have received the affidavit reply yet for the Lordship. Lordship, Mr. S. Toto is supposed to appear this letter, but he's out of station, Lordship. You kindly matter with it another day, Lordship.
In this petition matter, the notice under Rule 18 has been served to me. The petitioner in the market.
No, this matter came up earlier before this court. This court had asked these authorities as to whether it was a common land or the PNRD land. It has been held to be a common land.
Yes.
And if it is a common land, what is wrong with the issuance of the notice?
Yes, my lord, if petitioner acquired the bona fide claim of right, then not Rule 18(2) not applicable, because my lord, the petitioner running the business in the market matter openly for appreciable length of time matter. And my lord, the entry of the petitioner is not known to law matter. The petitioner allotted the plot of land matter in the market matter, and he carrying out his business matter since 1954 matter. In 1954, the petitioner foster father was in possession matter. Then in 1999, the petitioner has been allotted matter. In this land matter, the honorary division bench held that what is matter, the nature of the property and the duration of the land. The petitioner can claim a bona fide claim of right matter.
Judgment which year?
2022.
22.
my lord, 2022 GLT, the requirement to invoke the jurisdiction of under Rule 18(2), my lord. Paragraph 12, my lord. 12, 13, 14. In my lord, paragraph 6 in Amshi Petrochem and PLP.
Now this patta at annexure 1 has been extended.
My lord, it was not cancelled, my lord. Subsequently, we are paying the rent.
Since when? Since till
Since-
what time you have paid?
Since the issuance of the, my lord,
As of now, last payment made of when?
sixteen, my lord.
Huh?
2016.
Thereafter,
Thereafter, presently,
hmm, thereafter,
my lord, I don't know. Because the notice was issued on 2015.
so this is not a case under 18.2, it is 18.3.
No, the notice has been served under 18.2.
No, 18.3.
My lord, my lord,
See what?
page 30,
18.2 does not have a concept of giving you time. 18.2 concept of giving you time is not there. You may be immediately thrown out if you are in occupation of these. But this is a notice whereby you have been given 3 months time.
3 months time, but I have been not given an opportunity.
No, opportunity means whatever may be you had the opportunity from receiving the notice, vacate the possession of the land by removing the crop building walls which you have raised in the, otherwise as per law you will be forcefully evicted. So this is it. This is an under 18.3. It's not 18.2. Therefore those judgments would not apply.
But page 30, it appears 18.2, my.
Eh?
18.2, my. Page 30.
They may put it 18 to 18.3, whatever may be, they have, you may, yeah, but is there a concept under 18.2 to give you notice of 3 months? Is there a concept? On the other hand, it is 3 weeks or 3 days, whatever it may be. 18.3, look 18.3. What is 18.3?
No,
In
no,
any
yes,
other case,
yes. But my lord, the 18, whether it is 18.2 or 18.3, my lord.
18.3 does not have bona fide dispute.
But the procedure is the summary procedure. Therefore, I have submitted my that judgment, my lord, which referred the honorable appeals court judgment. That there has been there that the time, my lord, length of possession, my lord. If length of my lord, the appreciable length of time in its possession, my lord, for a considerable period, my lord, that judgment paragraph 6, my lord, and I have also the Supreme Court judgment also, paragraph 6, was referred, my lord.
This, you have been given the notice patta for only one, in 1999 for only 1 year. 1999, you are saying from 1954. This is from 1999.
But prior to that, kindly say that Bheti, my lord, in the dead Bheti, my father, foster father was asked to deposit the, my lord, the area rent, my lord. and execute the, my lord, agreement, my lord. I have annexed that document also.
You are on this annexure 1.
Even if the annexure 1, my lord, in the last sentence, my lord, you must kindly see the last sentence. The annexure 1, my lord. Annexure 1, well, this part will be cancelled after completion of the said period or before the completion of the said period. But there has been no cancellation, my lord. Therefore,
No,
my
no,
lord,
no,
they
no,
are
no, no.
accepting my.
No. Why you are reading only that line? If any illegal activity is done or violated any of the terms of the agreement, this patta shall be cancelled after completion of the said period or before the completion of. Why you are not reading the earlier portion?
I have not committed any illegality. That is not the ground. Matlab panchayat, matlab, panchayat does not agree. The market is running. Everybody is doing the business, matlab, by getting allotment, matlab. Why I am minor? This is the arbitrary minor. Why others are allowed to be carried out business? Why I am minor? If the market is closed, then I have no objection, matlab.
Have you raised any permanent structures on that?
Yes, with the due permission, my lord.
Where is the permission?
My lord, kindly see page 13, my lord.
Yes.
Regarding permission to start construction on the Bheti of 44 authorization. Please have information that as per order of the Honorable High Court, you are permitted to start construction on the Bazar Bheti.
No. Start construction of the Bazar Bheti number 44. But where you given the, did you ask for the permission to construct a permanent building?
My lord, that case, my lord.
When your particular document, the right which has been given is specifically that you cannot construct a permanent building.
Yes, I was served a notice, my lord. You cannot, you cannot construct the permanent building. Then I approached this honorable court, my lord. The honorable court, as per honorable direction, my lord, this permission was granted. And then I have to.
This court directed you to construct a permanent
No.
bheti.
Consider my lord application because my lord, others were permitted to construct permanent structure, my lord, in the market, my lord. On that ground, I approached the honorable court, my lord. The honorable, as per honorable court's order, my lord, this permission was granted.
Where is that order?
That order I have not arrested, but
then
sometime.
Why sometime?
All my lord, that.
The petitioner, the learned counsel, during the hearing, it has been duly submitted that in the same bazaar, various other persons have been allotted bhetis. And the said persons have also constructed permanent, also made permanent construction. It is the case of the petitioner that the petitioner made permanent construction only after due permission, which is evidence by annexure Roman 2. It is therefore the submission of the learned counsel for the petitioner that the respondent authorities have singled out the petitioner, whereas allowed the other persons who have been allotted the bheti to continue. In that regard, this court directs the SDC. Hosai,
We have 5 hours.
SDC, SDO, C, Hosai Songkotek Nagar, as well as the Panchayat and Rural Development Department of the Government of Assam to apprise this court as to whether the petitioner have been only singled out And if so, why? Also, the said instruction be placed by way of an affidavit. This the matter on 22nd of March 2022. The affidavit be filed by 19th of March.
Sixteen.
May please, your lordship. This matter has become impractical, your lordship. The petitioner has now
Still appearing on behalf of the
A.R. Gogoi.
yeah, the boy submit with Yes, what is this?
This is regarding, my lord, the elder brother of the petitioner, my lord, was kidnapped by the extremist, my lord. Accordingly, the FIR was lost, my lord, at base 13. FIR lost by the father, my lord. Subsequently, my lord, the father died in the year 2013. Although the father approached the authority but did not pay any compensation. And the police report, my lord, at base 23. Page 23, my lord, police report. Serial number 2, my lord.
Now, what are you asking?
Now, pray for ex gratia, my lord. And the response number 2, my lord, filed affidavit stating, my lord, the petitioner entitled the ex gratia, my lord.
1 lakh.
1 lakh. But, my lord, in terms of the, my lord, division with judgment, my lord, the petitioner is entitled 2 lakhs, 3 lakhs, my lord.
That Boro land. That this is Boro extremity.
Yes, my lord, for this is the authority of judgment.
Then why you are asking under 15/11/2014?
My lord, in the similarly situated matter, my lord, dispose of under the 1511 notification. My
How
lord.
do you bring in 15/11?
Yes, my lord. I have annexed the judgment, my lord. Order, my lord, at least 25, my lord. As per division bench judgment, my lord, the petitioner is entitled 3 lakhs, my lord. But in terms of the base 25 order, my lord, the petitioner is entitled 5 lakhs. In terms of the 15 notification, 15/11/2014 notification.
Huh? Why 5 lakh?
5 lakhs, my lord, come to page 25. My lord. In this case, my lord, fact is stated page 26, my lord. Victim was missing 2003.
What?
Page 26. Order of forbearance and others.
Other case, man.
Other case, my lord.
No. As per 15/11, you can't get.
Yes, sir.
You
Yes.
can only get 1 lakh.
No, my lord.
Yes.
As per Dhaneshwar first authorized judgment, my lord, we get 3 lakhs, my lord.
That is another scheme.
No,
Yes. There's another scheme.
this
Not on this 15/11.
not 15/11. Yes, my
Then?
lord. 29/7/2013.
Yes, that other one. Instead
Other
of a job.
Yes.
That it was given that earlier people who were there out there,
Yes,
who were
my lord.
killed out there, they used to get this 3 lakh rupees.
Yes, my lord.
That is it. Who
Yes.
have not applied. No, you have not applied as per the 29/7/2013 of it.
Yes.
That?
My lord, come to my lord paragraph 3, 4, 5, 10, 11, and 12, my lord, of the
Then
Donishta Goswami.
here it was said that those persons earlier
At
there
what-
used to be a notification where 1 lakh used to be given.
Yes,
Then they came up with an amendment in 2004,
4,
whereby they said that we are after this we are going to give you 3 lakh.
3 lakh. Yes.
Now this judgment is a case where it has been held that all those persons who have earlier also would get 3 lakhs. And therefore this new thing came up on 29/7/2013 that they will be getting 3 lakhs.
Yes, my lord. That is
But
why,
that is not your case in your.
yes, our case
No,
also covered by
absolutely
this donation.
And why are you approaching so late after 28 years?
My lord, the 13/11, 29/7/2013 notification, my
Forget
lord.
about the 29/7, but why are you approaching after such a long time?
My lord,
Why?
because my lord, the father expired in the year 2013, my lord. Although father approached repeatedly.
89 is the incident.
Yes, my lord.
You approached, your father expired in 2013.
13, my lord.
Then why you approaching to
17.
2017? Why? And your entire case is of 15/11. That-
Yes, my lord. 17.
Hmm.
My lord, there is the paragraph 11 of the Donishta Goswami judgment, my lord, whereby, my lord, the missing also covered. Missing parts also covered, my lord. I am reading the Donishta Goswami. I have given. Paragraph 11.
Understood, but why this is being filed after such a long?
Regarding today, my lord.
Show me your application.
My application.
Because now the payment will not be made by the home revenue. It has to be made by the home and political. And home
Yes,
and
20.
political is not a party here.
Case 20, my lord.
Home is made. Yes, where is that?
Case 20 of
Page?
the case 20, my lord.
NP.
20.
You are asking it to the revenue.
Revenue. Yes.
You should have asked to the home. You file it to home, they will consider.
Right.
It's the only way.
But all the notification are issued by the revenue department.
He is not fall under the
No,
notification.
no,
All
no,
the
no. This
notification-
payment is being made by home. This is from home, this is being done. This notification, the office memorandum of 2030 is
Yes.
by whom?
By
Personnel.
personnel, please.
So
Personnel people.
you have to submit it to whom? So they have to file before whom? Home, home and political.
Home and political.
Or to the deputy commissioner.
Deputy commissioner. In our affidavit, we have stated that his body was not, cannot be traced out.
Hmm?
His body cannot be traced out.
But 108 can be applied. So you make the inquiry. Find out. It has to be submitted to deputy commissioner. Deputy commissioner will take it first into quarter. We impose the cost upon you. No, for that cost. On the lawyer.
And
50,000.
with his application, he cannot annex.
You have encouraged the petitioner to approach it. So from your pocket 50,000.
Next of kin certificate also not annexed with the application.
So whatever may be, I am not directing them to pay. I'm only asking him to apply, and the authority will apply this notification of the personnel department dated 29/7/2030. The instant petition has been filed by the petitioner being aggrieved by the for seeking amendment, directing the respondents to recover the body, to recover the brother of the petitioner named Dinonath Bromno from the hands of the extremist group who were kidnapped on 25/3/1989 and had remained untraced till date, and in respect of which Kokrajhar PS case number 233/1989 was registered. The petitioner had also sought for a mandamus directing the respondents to pay the just and adequate compensation to the family members of the victim, Dinonath Brahmo, in the event that the brother of the petitioner could not be produced, traced out. The record reveals that from the record reveals that an FIR was filed before the officer in charge of Kokrajhar police station on 26/3/1989 by the petitioner. By the petitioner or by the father of the petitioner, stating in the earlier that on 25/3/1989 at about 5 p.m. his son one Dinonath Brahma went to the residence of one Korendra Brahma of village Basbari, but he did not return home. And it was known that some extremists had kidnapped the son of had kidnapped his son. On the basis of the said FIR, Kokrajhar PS case number 233 of 1989 have been lodged under section 364 of the Indian Penal Code. Subsequent thereto, on 14/11, subsequent thereto, on 24/11/1989, FR was submitted, stating inter alia that the contents of the FIR was true, but no clue could be found in respect to the person who had been missing. The record reveals that the petitioner herein, the father of the petitioner, or the petitioner herein the petitioner herein, on 28/10/2016, submitted an application to the Superintendent of Police Kokrajhar, PTAD, requesting for that the petitioner herein had submitted an application when? Where's the application?
It's 17, my lord, 28/10/2016.
Oh, where have you asked for money?
We asked for money page 20, my lord.
To the had submitted an application to the Secretary, Relief and Rehabilitation Department of the Government of Assam on 22/3/2017, seeking a compensation of rupees 5 lakhs. However, as nothing progressed, the petitioner has therefore approached this court by filing the instant petition seeking the prayers above mentioned. The record reveals that this court had issued notice on 11/12/2017 thereupon, affidavits have been filed by both the respondents, as could be seen from the records. In the affidavit filed by the respondent number 2, it has been mentioned that the case of the petitioner falls within the ambit of the notification of the Revenue Department dated 6/6/1996, and the amount of ex gratia that the petitioner would be entitled to is rupees 1 lakh. It was also submitted that although subsequent notifications have been issued on 19/6/2007 and 15/11/2014, but the said notification would be only applicable prospective, and as such the petitioner entitlement is at best rupees 1 lakh. In the affidavit filed by the respondent number 4, it has been also categorically stated that the police submitted the final report as they could not trace out the body of the victim, nor they could find the culprit, and under such circumstances, there is no accruement of right upon the petitioner for payment of ex gratia compensation at the appellate stage. During the course of the hearing, the learned counsel appearing on behalf of the petitioner submitted that the petitioner may not be entitled to the benefits in terms of ex gratia, in terms of the notification dated 15/11/2014, or it may not be entitled to the notification dated 19/7/2007, 19/6/2007, and 15/11/2014, taking into account that the incident happened in the year 1989. Even as it may, the learned counsel submitted that in view of the office memorandum dated 29/7/2013, issued by the Department of Personnel, Personnel B, Government of Assam, the petitioner would be entitled to an amount of rupees 3 lakh but this is only persons killed in extremist violence.
This is also kidnapped by accident.
So,
And my lord, the notification 29/7/2013 is issued in pursuance of the order passed by in WC, my lord, Dhaneshwar Hospital.
But this is only for killed it.
And yes, my lord, and paragraph 11, my lord, in the judgment, my lord. And
I forget what paragraph.
yes, my lord, paragraph.
But
11.
I'm asking you this.
Yes.
This only says killed. That in case of persons killed in extremist violence prior to 2004, but whose relative did not apply for any appointment prior to 22/6/2004 and had applied after 22/6/2004, or may not have received ex gratia grant under the 2004 notification, that is rupees 3 lakh. they shall now be entitled to appropriate ex gratia payment as per the notification dated 22/6/2004, adjusting the amount already received if any. It has also been submitted by the learned counsel appearing on behalf of the petitioner that as the petitioner had already, as the brother of the petitioner could not be traced out by virtue of section 108 of the Indian Evidence Act 1872, a presumption can be drawn that he had expired. This court have heard the learned counsel for the part and is of the opinion that as per the notification dated 19/9/2006, as per the notification dated 6/6/1996, the petitioner herein would be entitled to a compensation of rupees 1 lakh. Which was required to be sanctioned in 4 equal installments. It is also seen that subsequently, by another communication dated 19/6/2007, the payment of the ex gratia by way of installment in 4 installments have been reduced to 1 single installment. The record for the review that the respondent number 3 had duly admitted that the petitioner could only be entitled to an amount of rupees 1 lakh. As could be seen from paragraph number 3 of the affidavit filed by the respondent number 2 has admitted that the petitioner would be entitled to rupees 1 lakh. As could be seen from the affidavit filed by the respondent number 3 for paragraph number 3 of the affidavit filed by the respondent number 2. This court has also given an anxious consideration to clause 5, to clause Roman 4, capital small I of the office memorandum dated 29/7/2013, which categorically stipulates that only upon a person being killed in extremist violence, the beneficiary would be entitled to compensation of rupees 3 lakh. If the same office memorandum does not deal as regards a person missing. Under such circumstances, in the taking into account the overall facts, this court directs the deputy commissioner, which one district?
Kokrazam.
Kokrazam. to pay an amount of rupees 1 lakh to the next of the kin of late Dinonath Brahmo. Huh?
Yes.
Dinonath, Dinonath Brahmo. Upon submission of a certified copy of the instant order along with a next of the kin certificate, the said exercise be completed within 4 months. No, this is all you have already stated in your affidavit. Nothing.
3 months.
Within 3 months from the date of submission of the certified copy of the order along with the text. With the above the
Okay.
I have none has appeared on behalf of the petitioner for the interest of justice, the matter stands adjourned to be listed after 4 weeks on 1st of April 2024. It is made clear that if the petitioner is not represented on the next day, the instant petition
Wait, Peter.
Yes.
By way of this petition, I have challenged the cancellation order, Your Lordship. Initially, Your Lordship may kindly come to page 14, Your
Cancellation
Lordship.
of what?
Cancellation of a supply order. The supply order is at page 14, Your Lordship. Initially, this work order was given to me for supply of 5,000 dustbins. Page 14, annexure 1, 1-4. This is the initial work order, Your Lordship. Thereafter, at page 15, an agreement was executed, and finally, the supply order was given on 24-4 at page 18. 24-4. This is in the table, the second column, Your Lordship, second row. Supply of 200 liters capacity twin-liter bins at various locations in Tinsukia jurisdiction. This was given by the Tinsukia Municipal Board, the supply order. And the quantity was 5,000 numbers, and the delivery time period was fixed within 120 days. Accordingly, on the same day itself, since I have received the work order earlier, on 24-4 at page 19, Your Lordship, I have supplied 80 numbers out of 5,000. They have received it, duly received it.
How much you have supplied?
Only 80. On the
80.
same 80, yeah.
Out of
Yes,
500.
out of 5,000. And thereafter, Your Lordship, they refused to take the dustbin from me, time and again. And finally, on 15-7 from their side at page 20, they have extended the 120 days time frame. It was extended up to 24/11/2007. Thereafter, also they have not been taking my supply, the dustbins which I wanted to supply, Your Lordship. And finally, they asked me to give a letter seeking extension. I did. And without any notice, Your Lordship, at page 22.
Now what do you want?
So I'm ready to supply all the bins here.
Huh?
I want to supply the dustbins.
Now? You still have the supply.
Yes.
Dustbins with you.
Within the only your lordship granting the time just for transportation from Nagpur to Tinsukia, I can deliver it immediately within 30-50 days.
Why? Is it a case of breach of contract?
But I have already manufactured. It's a supply and manufacturing order.
So
They have asked me to manufacture. I have already
It's
manufactured.
a question of proof. You can claim a damage. The case of damages.
There are two parts, your lordship, supply and manufacturing. I have already manufactured as per their supply order.
See, as of now, has the court passed any order earlier?
Yes,
that you
your
can
lordship.
supply?
Yes, not to supply. The impugn order was stayed. Your lordship, that month.
Did you supply thereafter?
No, and the second part of that order itself, your lordship, will come to the order of 26/9/2018 passed by this honorable court. Prima facie, this honorable court held that the cancellation order without notice, and that too at the instance of a DC, is not enabling the law. Accordingly, the impugn order was stayed, and we were asked to approach the chairperson. We did. We went there. We held a meeting was held, but then again, without any specific order from this honorable court, he refused to take the supply. To receive the supply.
So there is no interim order passed by this court directing you.
No. That is why you couldn't supply.
So that is a case of breach of contract.
It's a case of breach of contract, but only I'm agreed only because there are two
So I
parts here.
think better of ask for damages. How can this court direct them for you to supply? Was the period of the contract not 120 days?
It was, which was
Can this
subsequently
court
extended.
extend the period or enter out here and ask them to kindly increase? You have a good case. You ask for that you have manufactured these quantities and this is the loss which we are going to suffer. Let's make two things. Question of directing them to take it. Does not arise as if this court will be entering.
Okay, but that I understand, you know. The manufacturing part that I have already done for that I can take the case, that I understand.
Understood. The manufacturing must have been done in 2017.
Yes. Well,
And do you know what is the state of affairs of that plastic waste because dustbin from 2017 to 2024? If you just stack it somewhere,
before supply, obviously the quality check and everything will be done, you know.
how can this court may say yes, this was wrong, but for you, you need to get it done. You got this court cannot direct you to step.
If the impugn order is satisfied, your lordship, then and if since the requirement is still there, that is the information, and I have manufactured, let them take the call. Let them give me an order. Your lordship. Within a time.
No. Why should I give a call? I may say okay, it was not done properly, but that is a subject matter of here. It's a breach of contract.
Lordship,
Is it required as per date that did they cancel prior to that?
prior to lordship?
Prior to the extension period?
No.
Your extension was granted till when?
24/11/2017. That was the extension granted.
24?
That is my period case, your lordship.
24/11?
2017.
It's 21. 21.
Yes.
We want an extension to be supplied up to 31.
That is our application, your lordship. No.
We have already supplied part of it. This is given till 24/11.
Yes, that
Then
your lordship will find that
It was
page 20.
rejected on 9/1.
991. No, your lordship. This is your lordship at page 26. The 26/12/2017. This is where the actually everything changed from 26/12/2017. The deputy commissioner, he on the basis of an inquiry report, your lordship, page 26, your lordship got it, and now at page 27, serial number 3. This pertains to us. If I may read, your lordship, this is what the finding of the inquiry is. The second column. The meeting held on 18/4/2017 under the chairmanship of chairperson so-and-so TMB decided to procure 5,000 dustbins. While taking the resolution in the board meeting, executive officer of TMD neither present nor informed about the resolution. This is false. I can show you, lordship. Instead, the JE TMB was informed about the resolution of the board for necessary action. Thereafter, the chairperson, without involving the EO TMB, issued supply order dated so-and-so directly to MS, the petitioner, Nagpur, to supply 5,000 twin liter dustbin with a capacity of 200 liters at the rate so-and-so. This seems to be contrary to office procedure in one hand and undue indulgence given to JETMB, defying the existence of EO and the other. But if your lordship may kindly now come to page, and on the basis, if I may complete, on the basis of this, the final remark of the DC action to be initiated is that the decision seems to be violation of all norms and procedure. Hence, it is suggested that the order is
where the payment could be made by the Tinsukia Municipal Board is in dark.
It may also be mentioned that
the violation of the FRPF Act.
yes. Now, your lordship, the deputy commissioner is not supposed to know first and foremost.
Huh?
The deputy commissioner is not supposed to know, and his allegation, his inquiry report, the finding is that first the executive officer was not in the loop. He was not informed about the work order, which is false, which itself is false, your lordship, because at page 14 and at page 18, the work order and the supply order, both were a copy of both were given to the executive
Now,
officer.
Mr. At that point of time, whether the board was
At that point of time, the board was functioning.
or it was at the suspended area at the board at period being over the
No. It was functioning. The board 2017 last meeting.
For the first time I appeared, the first time we appeared, so it's the second case. But only see, the page 18, the delivery years, 120 days, and it was extended on 24. Up to
So it is that it was cancelled after the period was.
yes, madam.
At that, it was so this court, I tell you, has to hold. Yes, the court can if they hold, but cannot give a directive. That this would be this court directive to execute.
Yes, that I understand. That will be the executive decision, your lordship. They may take the executive decision, your lordship. Only if your lordship holds that this interim order is in violation of law and it's
Why? What is the violation?
first and foremost.
What notice was required? No, in the interim order, there was a say that there was no notice. But where is the question of issuance of a notice when the period was already expired?
But that was the trick played upon me. I had to file a.
They had trick.
That is pleading on affidavit, your lordship. They have not countered. They have not countered. There is no affidavit in opposition also.
What do you want?
Countering my
Mr.
pleadings, your
Counsel?
lordship.
I give you two options: withdraw, dismiss.
Lordship,
I would have understood that during the extension period they casted it without notice. No, it is not that case. It is only after the period of 24/11/2017 was the last date. It was cancelled on 9/1/2000.
That I have explained, your lordship, and there is no affidavit opposition to counter my pleadings, your lordship.
Yeah,
On
but
affidavit, I have explained,
I
your
don't
lordship.
require a pleading for that. First, you have to go to satisfy. That is why I have not till now disturbed it.
Your lordship,
If this case would have come to me as a motion, I even wouldn't have thought about issuance of notice. I'm lucky to enjoy a stay order. And what type of
there is
stay?
no benefit, no benefit. I have not reaped
No,
any
if
benefit.
you have no stay, that stay has no benefit.
No benefit.
I would have understood that this court directed them that if it was necessary, asking the Tinsukia Municipal Board that whether it is required or not. And if they say it's required, then you supply and get pass an order at that point.
That can be done
Today,
now.
7 years have passed
That
by.
can be done now, your lordship. Just
This court can only do now either dismiss or very considerately allow you to withdraw.
Lordship, my humble submission is my cancellation order is not because the period was extended. It is not a case that I couldn't supply within time. And my pleaded case is that I wanted to supply. On the very first day itself, I have supplied.
It's a fact.
It's
It's
a fact now, undisputed fact, your
You
lordship.
said in your application that look here, I have the balance quantity.
Yes.
I will be submitting to you by 31st of something.
That may be kindly be read with the paragraph.
No paragraph is business for that. Kindly see. So give us extended up to 31 2017.
Yes, your lordship.
Kindly see your document at page 21.
Yes.
With the above, we want extension up to 31/3/2018.
Yes, your lordship.
And this was given on 24/1/2013. 18.
Lordship, 20 after the cancellation order was issued, your lordship.
Cancellation.
So I was
order
unaware. I was
well.
kept in the 9-1. 9-1. I was kept in the, that's why I was given the extension.
Where? There is no mention. Thereafter, the cancellation order was passed.
No,
by
cancellation
the-
order was passed on 9-1 at page 22. 9-1. And my extension prayer is of 24-1. Why will I seek for extension after cancellation? I was kept in the, I came to know about the cancellation order only on 1st February 2018. And thereafter, I
So
inquired.
be that as it may, you
Lordship,
did not know on first of
Lordship.
It's okay. But as on that date, you asked up till 2018.
Lordship, I was.
You asked for 31 feet.
Yes, that your Lordship may kindly come to
Why?
paragraph 9
No,
at page
what
6.
did you ask? Wherever there is briefly on the top.
I asked because that is what I have written. The chairman himself said that you will have to supply it within the last week of
Okay,
February.
Mr. Counsel, now I am fully
The-
satisfied.
Now, the
Is there a
Lordship,
case
Lordship,
of-
only one thing I want to show your Lordship. The first extension notice. Your Lordship will be clear. The first extension notice at page 20.
Has been filed by
Lordship, at page 20, your Lordship may kindly see.
filed by being agreed by the order of cancellation dated 9/1/2018 issued by the respondent number 1, whereby the supply order dated 24/4/2017 was cancelled. And also for the direction upon the respondent authority to accept the 5,000 numbers of 200-liter capacity twin-liter bin, which have already been manufactured and lying in the petitioner's stock in accordance with inverted comma manufacture and supplying order inverted comma close dated 24/4/2007.
Lordship,
From a perusal of the materials from the court, it repeats that on 19/4/2017, the chairman of the Tinsukia Municipal Board, on the basis of a resolution of the board dated 18/2017, asked the petitioner to supply 5,000 dustbin sets to Tinsukia Municipal Board. Thereupon, an agreement was entered into by and between the Tinsukia Municipal Board and the petitioner on 19/4/2017. From a perusal of the sale agreement, it repeats that the petitioner was required to supply 5,000 numbers of 200-liter garbage clean bin, which stand, and the total value of the entire amount of the contract amount was rupees 8,12,18,100. It was also mentioned in clause 2 of the state agreement that the supplier has to complete, the supplier, that is the petition, had to supply the entire order quantity within 4 months from the date of the purchase order of the work order at the destination in India. It is also seen that there was a quantified liquidated damages to be imposed if there was, if the goods, if the ordered quantity was not delivered within the stipulated time. The record further reveals that on 24/4/2017, the work order was issued. It is the case of the petitioner that on the very day, 80 numbers of the dustbin out of the 5,000 was supplied on the date of the work order issued to the petitioner. The record for the repeat that the chairman of the Tinsukia Municipal Board by the communication dated 15/7/2017 extended the period for another 120 days, that is from 25/7/2017 to 24/11/2017. Therefore, on 24/1/2018, that is much after the period of extension having ended, the petitioner submitted a request to the chairman of the Tinsukia Municipal Board that a further extension is required to be given on 31/3/2018 for supply of the garbage bin capacity of 200-liter twin bin. In the meantime, it is the case of the petitioner that the chairman of the Tinsukia Municipal Board, it is the further case of the petitioner that on 1/2/2018, the petitioner received an order of cancellation dated 9/1/2018. This order of cancellation dated 9/1/2018 have been impugned in the instant. It is also seen from the record that the petitioner had duly submitted a representation, but the state representation was not considered. The instant petition was filed on 29/2018. That is almost after 7 months from the date the petitioner received the order of cancellation. This court, by an order dated
26/9.
26/9/2018, issued notice and further state the order of cancellation dated 9/1/2018, and the representative of the petitioner was given the liberty to approach the chairman in Tinsukia Municipal Board so that the matter could be amicably sorted out. This court have heard the learned counsel appearing on behalf of the petitioner, Mr.
P.K. Sharma.
P.K. Sharma, as well as Mr.
S. Bodhakumar.
As Bodhakur, the learned counsel appearing on behalf of the Tinsukia Municipal Board, and appearing on behalf of the respondent of party, and Mr. S. Purva appearing for the respondent of three. From the materials on record, it is apparent that the petitioner was drafted a supply order for supplying 5,000 numbers of dustbins of 200 liters within a period of 120 days. Taking into account that the supply order was of 24/4/2017, the period ended on 23/8/2017. The record further reveals that the period was further extended by another 120 days by the chairman of the Tinsukia Municipal Board from 24/8/2000, 24/7,
90 days actually. The date was 24/11, extended up to 24/11. But they have written it 120 days. If it is 120 days is to be counted, it will be 24/11/2007.
but further extended
Up to 24/11.
24/11/2017. There was no further extension program. It is the case of it has been duly submitted by the petitioner. The petitioner wanted to supply the quantity. However, the Tinsukia Municipal Board did not permit them to supply. Be it as it may, on 9/1/2018, much after the period of extension being over, the supply order was cancelled.
That is what I just wanted to show page 20 because there were mistakes, Your Lordship. Just now, Your Lordship found that 120 days would have been expired on December last. And before that day, the DC inquiry report came. That is what I wanted to submit. It was
not on.
Yes, then I'll have to withdraw because otherwise I'll not be able to claim compensation also, Your Lordship. Imagine.
After the period, after the period of extension granted, expiry of the extension granted, the supply order dated 24/4/2017 was cancelled. It is the case of the petitioner that the petitioner wanted to supply, whereas the respondent did not permit the petitioner to supply, for which the petitioner had to incur huge losses in as much as the quantities in as much as the goods in question, the dustbins in question have already been manufactured. In the opinion of this court, the same aspect as alleged in the writ petition would be a case at best of breach of contract. And if there is a breach of contract, the remedy therefore lies with the petitioner under the private law for claiming damages. Under such circumstances, as no public law element is involved in the instant petition, and is purely a case falling within the the breach of a contract. This court is of the opinion that the exercise of jurisdiction under Article 2 to 6 of the Constitution is not warranted. Consequently, that this is not inclined the Constitution. This court, therefore, dismisses the instant petition on the ground of maintainable. Be that as it may, it is also relevant to take note of that the petitioner has remedy available for claiming damages if the petitioner is able to substantiate its claim in accordance with law. The same would require identification of facts on the basis of evidence, both oral and documentary. Considering the above, the petitioner is given the liberty to approach the competent civil court. Seeking appropriate remedies, including seeking appropriate declaration, including consequential relief of damages. So this court have also taken note of that the instant petition has been filed on 12th of, and the same has been pending for the last 8 years, 6 years, has been pending since then.
Right.
And the petitioner had approached this court on the basis of legal advice and have been bona fide pursuing the instant receipt. Under such circumstances, it is the opinion of this court that the period during which the petitioner has approached, the period during which the instant petition has been pending, that is, from 29/2018 till date, be excluded from the while computing the period of limitation.
Comment.
If it could have been done earlier, you have it for my time.
My lord, item 20, next item, what is in this case, my lord, I am going, today is my lord, FPT reply is being filed. And may it be listed after the week.
You don't have time.
20.
Have it. What's the item number with the
20 law. Next time.
I'm right, sure.
At number 23. Yes, here is the ACC Council. None appears on behalf of the council. None appears on behalf of the ACC on call. Taking into account the above, this court fixes the matter again on 6th of March 2020.
Hello.
Okay. Number 20.
Hello.
It is made clear that if the ACC is not represented next it, appropriate time.
May please. Lordship, the reply affidavit already been filed.
Hmm.
Can you want?
Your file reply. There is not come on record. Mr.
I am.
So appearing on behalf of the petitioner submits that the reply has been filed to the affidavit in opposition filed to response number 3. This is the matter. When? Any urgency?
Any paper.
Any urgency?
What?
What is the matter about? Oh, that matter. His urgency there for the forest. He's having a status quo order, isn't he?
But that is against the deputy commissioner's order.
Status quo as on today as regards the possession over the land shall be maintained. Then you are saying that this is a forest land. You don't have urgency.
Dr. May fix it in 3 weeks.
This is the matter again on 26th of February 2020, on which date the race shall bring on record. Yes.
Yes, my lord, the mother and wife of the petitioner died by this petition, my lord. And the engineer has submitted the affidavit, my lord. My lord, the inquiry report is annexed as page 20, my lord. And the contravention is mentioned, my lord, page 20.
You file an appeal. Who is appealing for the appeal?
Yes, my lord, I have just informed over the telephone, my lord, that they will prepare an appeal. However, there is no written instruction as of my
You can't prepare an appeal for all time to come. This is of 17/5/2023. Then we have to take it that there is no appeal.
Yes. As of now, we have not filed an appeal, my lord.
So
1 year back, we have already communicated with the Department of Housing and Inspection.
then if there is no appeal, then it has to be consumed that you have to pay that amount of 4 lakhs. 4 lakhs, huh?
4 lakh, 2% died.
Huh?
Mother and wife, my lord.
Then 8 lakhs.
So, lordship, I cooperated 1 week, my lord, I will then return.
Your name?
Peter.
Peter, the learned counsel appearing on behalf of the appeal, has submitted that he has no instruction as to whether the appeal has been filed yet, filed by the APDCL against the electrical accident.
My lord.
Accordingly, list the matter again on 26/2/2024, on which date the learned counsel shall apprise the court as to whether any appeal has been prepared.
Okay.
Yes, Mr. Bothakur.
Lordship, I'll have to seek updated instructions in this matter because Lordship, the last time it was taken up, quite some time has elapsed.
No, there was a direction for release of the vehicle.
Yes, Lordship, on to get the status of
2012,
that.
2018, there was a direction
Yes.
for release of the vehicle.
Yes,
You must have released it.
to get that confirmation, Lordship, may fix a short date. Lordship.
Okay, Mr. I. Bothakur, the learned counsel appearing on behalf of the respondent forest department. Take a week's time for obtaining instruction as to whether the vehicle of the petitioner have been released pursuant to the order dated 2012-2018 and as to whether there has been any further confiscation proceedings in respect to the vehicle. This is the matter again on 28th of February 2012.
Yes, mother of the petitioners, my lord, died due to electrocution matter.
Huh?
Mother of the petitioner.
Electrical accidents report?
Yes, my lord.
What is it?
Again, violated section 12 matter. Page 32, my lord. Operative person, my lord, page 34. 34 and 34.
So it is your.
My lord, we have not received the copy as of now, but not with us. So in that case, my lord, I will explain to my lord whether the appeal will prepare an appeal or not.
The record reveals that on 6th of April 2022, an affidavit has been filed with respondent number 6 to the effect that thereby enclosing the inquiry report of the electrical accident. From the report, it reveals that the accident occurred in view of the in view of the on account of contravention of certain provisions, contravention of the regulation 12(1) of the Central Electricity Authority bracket measures relating to safety and electric supply bracket close regulation 2010 on the part of the owner of the overhead line, that is the APTCL. It is not known as to whether the APTCL have taken any steps in that regard. Mr. Beach Das, appearing on behalf of the APTCL, seeks for an accommodation. To list the matter again on 28/2/2024. As regards for a further update as to whether the APTCL authorities have challenged the state inquiry report.
And the chairman, I took 45, 14 sector. 40.
What is that? Same.
Case method, no, contempt case, 40 complex.
It is different.
Exactly.
So we'll have it when 45 comes.
Right. May I speak? My lord, this application for my lord, renewal of the license of the petitioner that has been filed, my lord, on.
Yes, why? Why your license has not been renewed?
It was in the year 2018.
Hmm.
Because, my lord, there is a, my lord, case against the petitioner where he has been declared, my lord, foreigner. Now, in that case, my lord, Honorable High Court has passed an interim order. Interim order is holding the field. Now, in view of the, my lord, interim order passed by the Honorable Court, the authority, my lord, cannot hold the, my lord, license without, my lord, renewal. Now, Lordship will find, my lord, the order passed by the Honorable Court at page 34. And property part, my lord, page 35.
This matter is still pending.
Yes, it's still pending.
That's the last order I have taken print out. This is the last order is of this case, my lord.
How do you say that it has not been extended for that reason? That he's a foreigner?
Lordship, as a received one office note, I'm appearing for the first time in this matter, Lordship, an old pending matter from the office of the DTO Bongaigaon. The foreigner tribunal had written to them that he is declared as a foreigner. After that, no up-to-date order copy of his honorable was received by the DTO.
But again, it's an interim order. If it is renewed, then you keep on, and tomorrow it is dismissed. What will happen?
Then it will be.
Then you will use that in Bangladesh.
Everything will be. Everything will
You can't use this in Bangladesh. Huh? List the instant repetition after disposal of
Subject number 489.
4891 of the 2017 pending before this court. The petitioner is given the liberty to mention the matter as and when the petition number 4891 of the 2017 is spoken.
Deeply obliged, my lord.
Obliged.
Happy Jola.
Hmm.
Oh, this is repeated for non-payment of a petition against land acquisition.
Non-payment of what?
A petition. Land of the petitioner was acquired, and initially an amount of rupees 9,58,500 was paid was the value of the land. So let's look at it. Paid 8 para 9 of my petition.
Then
Paid 8 para 9. And my further amount of rupees more like 82,000 was paid as interim payment for Girard structures, which was received by the petitioner under protest. Thereafter, petitioner applied for reassessment of the Girard and existing civil structure. Then this was reassessed, my lord, intelligence of all concerned. A phase list was prepared, my lord. Let me kindly be seen the statistic. According to this reassessment, my lord, I am entitled to getting rupees 14,89,334 towards destruction of civil structures and Girard value.
Then
This amount has not been paid.
how will it be paid? How can that amount be paid? Tell me.
Well, in this case,
You are a very important, prominent civil lawyer. Tell me, how can this be paid in a proceeding where the payment will be made as per the award?
Fine.
The award has already been passed.
Award is, this is
Under such circumstances, can the deputy commissioner or the collector have any business thereafter?
well, this is reassessed award. This is also awarded award.
This is not reassessed.
Reassessed.
How can that be an award? Told me this is not an award at page 36. It is not an award. How this sectional officer PWD cannot sign on an
No,
award.
my lord, your lordship, I cannot see their activity now filed by the DC, my lord.
Then also the DC has no business out there.
That's
That
what
is the
number-
problem with this
That's what
DC
number-
too.
That's what number 3, my lord.
Huh?
That's what number 3, my lord.
What does it say?
Para 6, my lord, case. Para 6, my lord. Para. Accordingly, the executive is a building division 2, what is submitted the assessment report. So it was on 16/8/12. The building division 2 access the Girard. This is a wall building, it is access for rupees so and the value of the valuable trees were also assessed for rupees so on the basis of approved rate of agricultural department government of Assam. Accordingly, total Girard value of the layout item was assessed as so. The requiring department of executive engineer NS division what has been requested to deposit the additional compensation amount which has not been requested. That's why it could not be.
The question does not arise yet. Therefore, there is no award passed. It is not possible. How Once an award has been already passed, these authorities have these, you can take all these things in and proceedings under section, this is done under section, what do you call, you have to move under section 18. There's no way out. You see, the only manner in which the award can be tinkered with is by the authorities under section 18. There's no other way. There's the law laid down by the Supreme Court in Tata. Sorry.
If my lord, there is dispute in respect of assessment,
Whatever may be.
My lord, then
Whatever may be. As of now, if the deputy commissioner writes anything also, there has to be an approval, which means, does the deputy commissioner, as per the 1894 Act, has the jurisdiction to assess and pass an additional award? Not possible. There's only one award.
That award was my lord unilaterally passed. That was not in places of the petitioner, my lord.
Whatever may be,
And my lord, that award was
that is why you need to challenge the award as per law under section 18, taking a reference. There's no other way.
That has been challenged, my lord. That has been challenged by filing an application. Then, my lord, reassessment order was passed by the deputy commissioner.
How can the DC pass that order? Tell me.
My lord, he is the
DC has no business.
he is the land acquisition officer, my lord.
He loses. He becomes functions official once the award has been. He becomes functions. There's no way out. Show me a provision that the DC can reassess then. No, that is not permissible.
My lord, if award has been objected or protested, my lord, then this can be reassessed, my lord, by the DC.
What do you want?
I'll satisfy your lordship, my lord.
No, satisfied? Not there. Now I'm asking you, what do you want? A dismissal completely? Or you want to go under section 8? Either.
Well, my right of approaching under section 18 has been made, my lord, because it has been reassessed, my lord, I'll satisfy the reason.
So these are the things, materials you will place it before the section 18 court. That's all.
My lord, this award was, my lord, in connection with land acquisition case number 30.
So?
Wherein, my lord, the similar order has been filed by the court. I have
This court is not going to pass that order. Show me the provision under what, how the DC can reassess. It will be a never-ending matter,
No, my lord,
isn't it? Who is appearing? Is it permissible?
yeah, to go to
The collector will refer it.
There's no way out. There's only way to be done by the making a reference. The law is well settled. The award becomes final between you and the person into the DC and the person interested. DC can, and this court cannot confer a jurisdiction. And if this court has done it, that is wrong. I'll say it to be per inquiry. I mean, one day I can do it.
my lord, I'm satisfied. One day, I will.
I'm not satisfied. Even to adjourn it for tomorrow.
On Monday, my lord. On Monday.
No, today.
On Monday, my lord. Tomorrow there is no court.
Tomorrow there is court.
Tomorrow is working. Monday, my lord.
No,
Tomorrow
no
I'm
Monday. This is not going after 2:30. This matter needs to be disposed of now. Unnecessary litigation.
All right, my lord, I may be allowed to approve the land authority other section.
Yes, that is the only way out. The instant petition has been filed by the petitioner, being agreed by the inadequacy of the compensation granted to the petitioner without taking into account the actual amount to which the petitioner is entitled to on account of Jirat.
Civil structure.
And
Civil structure.
that is Zirat. On account of the Zirat. Therefore, under such circumstances, the instant petition has been filed seeking a direction upon the respondents to award an amount of rupees 13,06,680 for the balance payment of Jirat in accordance with the provisions of the Land Acquisition Act 1894, along with interest. This court has duly taken note of the facts involved. which shows that the land of the petitioner was acquired in LA case number 13/2017. The award was passed pursuant to the approval being granted by the government on 17/3/2010. Thereupon, the petitioner being aggrieved with the inadequacy of the compensation had submitted an application before the Deputy Commissioner requesting for reassessing of the compensation for the standing jirat over the acquired land. However, the Deputy Commissioner, instead of making a reference under Section 18 of the Land Acquisition Act of 1894, passed certain instructions, thereby directing the Circle Officer Guwahati Revenue Circle as well as the Executive Engineer PWD NH Division to conduct the survey and on the basis of the said survey being conducted, it was found that the petitioner was entitled to another amount, a further amount of rupees 13,06,670. Be it as it may, it is very relevant to take note of that it is well settled that when an award is passed by the collector in terms with the provisions of the Land Acquisition Act 1894, the award is final between the person interested and the collector. And the same can only be interfered with by the civil courts in accordance with the provisions stipulated under the Land Acquisition Act 1894. It is the opinion of this court that such action on the part of the Deputy Commissioner to go for a fresh assessment of the land, the value of the land, it is the opinion of this court that the Deputy Commissioner oblique the collector would have no jurisdiction to again make reassessment on the basis of the inadequacy of the compensation after the award has been passed. Under such circumstances, it is therefore the opinion of this court that the writ which has been sought for by way of the instant petition cannot be issued in the facts of the instant case. Be it as it may, this court duly takes note of the facts involved and to the effect that the petitioner had duly submitted a representation before the collector, before the Deputy Commissioner. Which one?
Kamrup Rural.
Huh?
Kamrup Rural.
Kamrup Metro. Guwahati now, rural.
Metro. Kamrup Metro.
Had submitted before Kamrup Metro, which ought to have been made, and on the basis thereof, a reference ought to have been made by the authorities concerned, by the state authority, in terms of Section 18 of the Land Acquisition Act 1894. But the same was not done, and instead, the Deputy Commissioner, Kamrup Metro, initiated actions which was not permissible under law. Under such circumstances, this court grants the petitioner the liberty to file an application within 42 days from today before the Deputy Commissioner, District Commissioner, Kamrup Metro, seeking a reference on the aspect of inadequacy of compensation in the award. And upon such application being filed, the Deputy Commissioner shall, in terms with Section 19 of the said Act of 1894, make a reference to the principal civil court, to the court of the district judge, Kamrup Metro, forthwith and not later than 30 days from the date of such application. With the above observations and directions, the petition therefore stands disposed.
May Peter.
Hey. Yes.
Matter relates to lordship non-payment of bill lordship. Petitioner has supplied some stationery goods
To
to the printing and stationery department.
then
Then lordship, respond number 4 has filed one affidavit lordship and they admitted lordship. Paragraph 5 lordship, 5, 6 and 8. They have admitted.
why they are not paying?
Lordship, that is mentioned in paragraph 8 of their affidavit, page 50.
Who has filed this affidavit? Who is to pay? The DC.
DC lordship. DC filed this affidavit.
And why they are not paying?
Paragraph 8 lordship, page 57.
Who is appearing for the election? Is the State Election Commission.
No, Lordship, this is for Election Commission of India in order.
Where is the Election Commission of India is not a party?
Lordship, implemented letter on
Why
lordship.
the Chief Electoral Officer is a party? Where is he?
Election Commission of India also part.
Where?
Yes, respond number 5 to letter
Ah,
on implemented.
where? Why the Election Commission of India is not represented? What do I do? I think we will seek their representation better off and direct them to pay in their presence. I can pass an order directing them to pay within 3 months or 4 months, as it is an admitted fact. But the question is, without their presence, it may not be so effective.
Yes, that will be better.
When the matter has been called for,
In fact, Lordship, we have received an instruction from the district election officer.
I've read it. When the matter has been called for, the respondent number 2 and 5, that is the Election Commission of India, as well as the Chief Electoral Officer, is not represented. From the materials on record, it reveals that the amount claimed by the petitioner to the tune of rupees 35,71,718 have been duly admitted by the respondent authorities. And more particularly by the district election officer Kamrup. However, the said amount has not been paid in view of the fact that the Chief Electoral Officer Assam as well as the Election Commission of India have not released the funds. So, taking into account that the respondent number 2 and 5 are not represented, this court for the end of justice adjourns the matter to be listed again on 20th of April.
Before that.
To be listed on 6th of March 2024. It is made clear if the respondent number 2 and 5 is not represented on the next date, this court shall pass appropriate orders in their absence.
Because this may also reflect
the registry shall show the name of Mr. I.A. Ali, the Learned Standing Counsel of the Election Commission.
Apply.
A.I. Ali or
AI.
AI?
My lord.
Yes, what are these matters?
My lord, may take up item number 30, my lord. This is a connected matter. What happened in this case, my lord? The petitioners were allotted shop rooms in the newly constructed market by the Chapo municipality.
You are appearing in which matter?
My lord, I am appearing both the matters. I'm both the matter.
Okay, then.
The notice inviting application for allotment of rooms was issued on 26 and 18. And then on 25/11/18, rooms were allotted to the petitioner and an agreement was entered into and part payment or advance money was also deposited. Now, in the meantime, my lord, the tenure of the chairman was over and the board went under the chief executive officer, who without cancelling the earlier allotment directed us to take back the money. And when we refused to take back, he issued one fresh NIT or notice for allotment of this same room. At that stage, we approached this honorable court and the stay order was passed.
In this case, I need some time now.
And no affidavit has come.
Who is appearing for this? Who has done? Chopon Municipal Board.
Yes, yes, sir.
Who is appearing?
I'm appearing.
Sir?
No, give me
It's a
the list.
matter of 2020, does
Sorry,
it look
sorry,
like?
Sorry, no.
4 years?
Give me one chance, sir.
Earlier also, all these people have been appearing asking for time.
What?
Mr. N. Goswami appearing on behalf of the respondent, all the respondents. All the respondents?
What?
Obviously, you can appear for DC and all.
What?
Appearing on behalf of all the respondents, including the municipal board.
What?
6 for an accommodation for filing the affidavit. So, list the matter again on 11th of March 2024. The affidavit be filed by 4th of March 2024. Fourth, the petitioner is to advise to be at liberty to file the reply. In time order passed earlier shall continue till then.
Apply.
Sometime if I ask Thakur, he will appear for the PCL notice.
Affidavit filed.
Affidavit file or notice. On 9th of he told me that he file already filed on 9th of.
Okay. Now? Yes, madam. Not filing reply.
My lord, I could not contact the petitioner myself.
He must have lost his hope seeing the affidavit in
No,
a
my
copy.
No, my lord.
Then?
Not that, but I just could not contact him. He stays in Sadiaman.
Huh?
He stays in Sadiaman.
Then
That's the problem, my lord. The
Korea
connectivity
is
is
too
very,
far off,
very poor, my.
very far off.
No, my, not very far. Very connectivity is very poor. So I tried my best,
Is
my
it?
lord. My lord, in affidavit, whatever they have stated, my lord, some things are in my favor. No opportunity is given to me, my lord, as per their own approaches, my lord. Rules and
You are asking for money.
my lord,
You are asking for money only.
not money, my
Huh? Why the impugn order should not be suspended
money.
against illegally and
want
arbitrary
settlement,
why
my
should
lord.
not be given an opportunity to submit land documents in origin on demand and as why land document that he has submitted within the stipulated time in respect shall not be accepted by the leadership. The learned counsel appearing on behalf of the petitioner submits that the affidavit in opposition has been filed with response number 3 on 9/2/2024. Petitioner would like to file a reply to the same. List the matter again. Do I have urgency? No urgency. No urgency. List the matter after 4 weeks.
Obliged.
In the meantime, the petitioner would be at liberty. Yes, what is this?
In this case, Your Lordship, there is a contradiction whether accident took place due to
Huh?
flat or not, Your Lordship. In this regard, oppose.
4 lakhs.
Yes, Lord.
Death due to
Flat.
flat.
Yes,
Not
Lordship.
there is a
And
problem
there is
in that case.
contradiction. Respondent
Flat
also-
or you went to a ditch. Pond.
Yes.
So that pond wala man.
Yes. Yes.
Okay. Yes, I remember. Then
Uh,
you go out there to the pond. You and your uncle.
Uncle.
Yeah. Both of you went out there for fishing.
Yes.
And then you got yourself drowned.
Not fishing it.
And now you are saying it to be flat
Yes.
and a disaster.
Sure.
My God. What do you want to do?
Lordship, as per
Huh?
dispose of it or as per merit of the
Dispose it of on merit. Saying that you are not entitled to.
Lordship, I have already submitted a order also
What order?
in earlier occasion. Lordship, Rafiqul Islam, petition number
Huh?
438/2021. In
What?
this case, Your Lordship, similar situated matter, Honorable Court consider the petitioner case as per the notification 15/11/2014. The public place. If
Public place.
Yes.
The pond was a public place.
So,
Here the pond was a public place.
No.
Then
The private place, Your Lordship.
Allah. Chalo, let the death of the writ petition be in the hands of somebody else next week. What do you think? I want to dismiss it right away.
Good.
The instant writ petition has been filed by the petitioner. Being aggrieved. And the inaction on the part of the respondent authority in making payment of the amount of rupees 4 lakhs, which the petitioner claims to be entitled to, as per the notification dated 16/6/2015, issued by the Revenue and Disaster Management Department, Revenue Relief and Rehabilitation Branch, and Disaster Management Department of the Government of Assam. From the materials on record, it reveals that the son of the petitioner expired due to drowning. The police report enclosed to the Annexure 3 to the petition revealed that the petitioner's son, along with his nephew, went to take bath in a fishery pond of Baharul Islam, situated at number 1 Hatipara PS Boko. But unfortunately, due to excess flood in the area and in the pond, both the minor boy fell down in the pond, and later a search was made and recovered the dead body from the pond water. It is under such circumstances that on 21/12/2020, the petitioner submitted an application seeking financial assistance to the Deputy Commissioner, Kamrup Rural, on the basis of the notification dated 16/5/2015. And the claim was made of an amount of rupees 4 lakh Pursuant to the filing of the writ petition, an affidavit has been filed by the Circle Officer, Boko Revenue Service, wherein it has been mentioned that the accidental death, drowning, of the son of the petitioner on 16/7/2020 happened when both the son of the petitioner and one Azaz Ahmed went to take bath in a private fishery pond of one Baharul Islam, but unfortunately died due to drowning. It was specifically mentioned that it is no way a flood-related death. Taking into account the above, it is the opinion of this court, as the death on the part of the son of the petitioner was not on account of any floods, which can fall within the ambit of the term disaster mentioned in Section 2D of the Disaster Management Act 2005. 5. It is the opinion of this court that the petitioner would not be entitled to the writ as sought for. Consequently, this court finds no merit in the instant writ petition, for which the writ petition stands dismissed.
Lordship, kindly pass over for timing, Lordship. My senior is on his way.
What? Timing? What is this timing business? What are you asking for?
Actually, अपने अपने calendar recovery notice लौटे. My senior is on late. Kindly pass over for timing loss. Only for 5 minutes left.
No timing. Let it come up after next week.
Kindly fix the date.
At the request of the Learned Council for the petitioner, matters can adjourn to be listed next week.
On 20.
Huh?
20.
20?
22.
22.
February.
Why 22?
No, 20
I mean,
February.
auspicious day.
No, Lordship. Another enactment is also.
And so you come only one day.
No, no.
Absolutely no. Let it be on 28. 28.
Supplementary list, item number 58.
I thought in this matter, maybe granted some accommodation. The briefing council is out of session in connection with her treatment. But there was an order of your lordship pursuant to which an affidavit was required to be filed. That has not been done. And last occasion also it went unrepresented.
Yes. Who is paying for the Jorhat Municipal Board? What happened? You passed the order.
Lordship, hearing will take place today, Lordship.
Huh?
Today hearing.
Yes, my lord, today fixed for
Hearing,
both the
Lordship.
party asked it.
Hello. The Learned Council for the Jorhat Municipal Board submit that the hearing in respect to the matter pending before the Jorhat Municipal Board is presently being taken up today. So consequently, this matter stands adjourned to be listed again on when?
After 10 days.
10 days. On 11th of March. Yes, you wanted to withdraw.
My lord, with liberty, my lord.
What liberty? Tell me.
My lord, petitioner applied for this Bosundara scheme, my lord.
You should not be directing the petitioner authorities to allot settle the land of Khatian number so and so in favor as per the provisions of so and so. Yes, then. Because if I remember, when the matter came up before this court, there was no Khatian or something like that.
My lord.
So I said that how can you come under 16, taking into account 16 will only come under when you have you are an occupancy tenant. You may at best come under 17. Is this the case? Is this the case?
My lord.
Very good. Now you want to withdraw
My lord.
and file an application.
My lord, already petitioner applied Bosundara scheme, my lord. That application is now pending, my lord.
So very well. If they do whatever it is, if you don't get it, then you can always at liberty. That is a fresh cause of action.
Liberty may be given, my lord.
For what? You want to approach the authorities concerned with a shadow. The Learned Council appearing on behalf of the petitioner submits that the petitioner have already applied under the in terms with the Bosundara scheme of the government of Assam. And as such, the instant writ petition, which was based upon the application of Section 16 of the Assam Fixation of Sealing on Land Holdings Act 1956, has become infructuous. Taking into account the above, this court therefore closes the instant writ petition as infructuous. It is made clear that the rendering of the instant writ petition as infructuous it is made clear that the closing of the instant writ petition as infructuous would not in any manner prejudice the petitioner in such proceeding in their or his or their in how many petitioners in the petitioner in their applications so filed seeking allotment. Hmm.
You were directed to obtain that.
What? That day I wanted to dismiss your petition or
No,
something. No, I
One
wanted to
petition
allow it.
Honorable Court was allowed,
Huh?
and one petition was allowed, and this no instruction has received. That is why.
How much amount has been paid?
Vehicle can relay.
May I submit, Lordship?
So the payment has been made.
May I submit one thing, Lordship? In this subject, will the column, Lordship, the repetition number is defined, Lordship. And
Huh?
the vehicles numbers are same, Lordship. You can clarify.
No, no. I have seen annexure 1.
Look.
The payments have been made.
No,
As
no,
it say.
instruction logic, instruction logic, in the subject column logic, there is a repetition number, there is different logic.
Oh. But the vehicle is same.
Vehicle is same.
Same period.
Vehicle is same.
Innova.
Innova. Vehicle may be same, but different period is there.
Periods are same.
Periods are same. Logic.
Give it to him. Disconnect a document. Give it to him. See, kindly come to pay annexure I, annexure 1, page 13. Oh.
Some difference is there.
Huh? What?
Actually, Monday and 6, I will take instruction matter.
Problem arises is that in your petition, you don't categorically mention what is the bill number. You don't mention anything.
I have annexed the bill, your lordship.
What annex the bill? Kindly see annexure 1. This is the period for which you are asking. The period has been mentioned in that communication.
Yes,
the same period.
Same period. Lordship.
Having the same vehicle number. That is what I am saying.
Maybe 6 on Monday, I will take instruction matter.
Mr. N. Goswami, appearing on behalf of the respondent, submitted that the bill of the petitioner in respect to the amount so claimed as reflected in annexure 1 to the petition have been duly paid. Mr. L. Mohan, the learned counsel appearing on behalf of the petitioner, seeks some time to obtain instructions. List the matter again on 28th of August, February 2024. The instructions were placed before this court, it took on record and marked with the letter X.
Your Lordship, kindly accommodate me for the day, Your Lordship. My senior, Mr. Kenshaw, had to deal with some personal difficulty, and even our engaging counsel is also not now.
Oh, this matter, nothing remains.
Yeah, TA, TD notification, I have to give by way of affidavit because that it was not legible. That is why that seemed to be submitted for affidavit.
This
and
court
it-
directs the area to place on record by way of an affidavit the publications were made in terms with plans of the national highway.
So I have filed affidavit, but
You have filed.
I have filed.
So they
Got it.
filed it.
You got it.
Respondent number 4 is who? You.
I have filed it, but
We
I
have
think
the soft copy. We don't have the.
You have filed affidavit.
yes, my lord.
Then you have enclosed.
Please, whatever, my lord. Actually, I also again taken out the paper which was published original I could not because photocopy is now it is also not. That is why I also has tried to bring from district library or somewhere else this copy or from the press itself.
PA to be made in 2 local newspapers.
That
one
was
of
made
which is
actually. That is made. He did both are made, published in local. That is in Sentinel and Amarasam. But problem is, my lord, this original copy, I also could not get it now. Today also tried to district our library also to get the copy, actually original copy. I'm also not getting anyhow today. To
Mr. Borua, you appear for NHI.
NSI DCL.
Whatever may be. That yesterday there was a matter.
My lord.
I had taken up, I think, who was it? You can ask Mr. Arbor Putari.
Barbujari.
Barbujari, because I could not take up the matter yesterday because of the fact that NHAI or NHI DCS was not present. Yes, he was.
Yes,
That matter.
Yes.
I did not take it up because they were not present.
Yes, Lido Tea Company,
Lido. I fixed it on
7th of March.
I'll find out because some other council may be engaged because I'm not in that case. At Lordship, I'll find out.
Find it out. Because it was not represented. That is why I could not finish it.
I'll find out. Today itself I'll find out who is the council, who is being engaged for in this case, particular case. I'll find out. If not, I'll take instruction.
Because there are 2 writ petitions.
My lord, I'll take.
One writ petition pertains to payment of certain amount, which a payment as per the old act it was done, but the latest new act it should have been done, it was not done. So this court will direct for making a reference. But there is a bigger problem there. What happened is they acquired under 1894, gave the land to PWD, PWD gave it to NHAIDCL for constructing. NHAIDCL has constructed. Now NHAIDCL says that we don't pay compensation in respect of government land. Because in the meantime, it became acquisition, it became a government land. Now, because of that, the problem arises. Now, their thing is, PWD thing is that we don't have the land. Why should we pay? NHAIDCL says that why will I pay? And more so, NHAIDCL's basic contention is, if they had done, because this was done on 19/1/2014, they say that if it was done under the National Highways Act, then they need not have paid. Because it was NHAIDCL National Highways Act was brought within the 4th schedule of the new act. And as such, the compensation has to be as per the old act. So that is why NHAIDCL's aspect is there. That is one. But the second writ petition is a bit dangerous for you. The second writ petition is where they have not received a single penny. Now, if it is not being done, wouldn't it lapse? Because both of you are fighting who is going to pay. So if it lapses, now they return the land back to them. And what will happen to the national highway?
I'll take from him number.
Okay, Mr. C. Volva appearing on behalf of the respondent, NHAIDCL, submits that the newspaper clipping, in the newspaper advertisements in respect to the publication made in terms of section 3A, capital A, bracket 3, could not be placed before this court, taking into account the same could not be traced out. Full stop. However, sought for a short accommodation so that the same could be obtained. Accordingly, list the matter on 15th of March 2024. In the meantime, the affidavit we filed.
The affidavit I filed.
In the
Affidavit I
meantime,
filed.
an affidavit, the said newspaper
will be placed.
Advertisements be brought on record by filing an affidavit.
TPO.
Why?
No, we have not received inspection lordship. It is all pending matter lordship.
It should come up for admission.
Lord.
Or why?
Because of the one police case lord.
Hmm? List the matter again on 21st of February 2024.
21st, I would not be here. 22nd.
22nd, not what is that for matter?
23rd.
23rd of February 2024. On in the admission column. On which date the learned counsel appearing on behalf of the state respondent shall produce the instructions as sought for by the order dated 19/1/2024
Applies.
without fail. Yes, none has appeared. It has been filed. The instant contempt application has been filed, seeking initiation of contempt proceedings for willful disobedience and violation of the order dated 29/4/2014, passed by this court in WPC number 4673/2009. This court have duly perused the order dated 29/4/2014, passed in WPC number 4673/2009. From a perusal of the said order, it reveals that this court had directed the departmental authority to re-examine the issue by taking note of the petitioner's reply dated 24/9/2009 and thereafter to take a fresh decision on the contract in question. The said aspect was on the basis in the context of forfeiture of the security and penalty of rupees 3,600, 3,60,000 ordered on a context of forfeiture of the security and penalty of rupees 3,60,000. It appears that when the instant contempt application was filed, there were the opposite parties therein. It appears that From a perusal of from the contempt application, various respondents have been impleaded. And it is also seen that the said original respondents have retired, for which there has been impleadment of the incumbents as would appear from the order dated 21/6/2016. The question as to whether the said order has yet been complied with or not, and further as to whether the respondents, the said income, the respondents are presently holding the post, who are in a position to comply with the order passed by this court, cannot be ascertained, taking into account that the petitioner is not represented. Consequently, this court therefore closes the instant contempt application. Yes, what is this?
In this case, there is an order on 4/6/2014 that has been violated by this contender. The direction was not to evict the petitioner from the land in question. The page number.
Oh, that where he has broken all your houses and all, in spite of the order being served. Yes.
The affidavit has been filed by the concerned circle officer. In page number 37, it has been mentioned that at the order of this honorable court was brought to the notice of the deponent, the deponent would not have evicted the petition. So, the contention of the consent container number 3.
Then
this is the case, and this is the reason why it has been listed today. For consideration whether there is any willful violation of the direction of the admitted position, the construction has been demolished. In their affidavit also they have admitted that thing, annexed all the documents, the photographs.
Yes, Mr. Sekia.
If I am appearing, of course, Lordship, that is the correct factual position. Had he knowledge of the deponent concerned, Lordship, nobody would have dared to violate any court's order, number one. And when he joined in 2013, there was an order of 2003 and 4 that restoration of the original cancellation of the patta. Those records were never corrected. Till date, it is not corrected, Lordship. We'll definitely do it, Lordship. But the fault does not lie with the concerned deponent, the circle officer of that point of time, Lordship. He was there. It was not known to him about the order. It was never placed before him also. Although they have stated that it was submitted, but they have not furnished any proof of submission of the Honorable Court interim order in the office of the Deputy Commissioner, Lordship, or of the circle officer.
Understood, but the government advocate was very much present.
The government advocate was definitely present, but the contemner ought to have come to knowledge. Maybe there is fault on the part of the government advocate also. That is number from 2014 to 2019. No affidavit was filed also. It's a very old contempt case.
You are after all the Advocate General, so I think
Yes,
you
I
should
take
also
responsibility.
instruct your persons concerned that whenever an order is passed, irrespective of the copy being served or not, when there is a question of demolition or anything, the government advocates should intimate.
Absolutely, Lordship. Now those government advocates are also not there. The officers are also not there. There was a different set of Advocate General at that point of time, Lordship. So I take full responsibility whoever has committed the mistake. But this officer, Lordship, it was not to his knowledge. Otherwise, he would not have done. He is an officer for about 30 years. He is in the fag end of his career, Lordship. He is now the election officer in Morigaon district, Lordship. He seeks unconditional apology. But had it been
But the land is in Borsabil.
Now that has become a part of that water body there. So ultimately, they are still in possession. Still in possession. It is not that they are.
No, the Borsa Bill Act came when that.
In 2008, it has came. It has.
2008.
The order for restoration of the patta was of 2003. My Lord Justice Agarwal's order.
Hmm.
So now,
whatever may be,
now we will have to acquire it through proper legal means. Just what we have done in Kilkhaku Lordship. The same thing will happen here also. But they will get compensation. And I don't think that they will have any objection also for that. These are water bodies, Lordship. Rightly, wrongly, it was allotted to them in 1991. In 1995, it was cancelled. And they came before the Honorable Court. There was an order for restoration of the patta. But the land records were never corrected. And therefore, the circle officer had no reason to think that this land belonged to that particular patta holder. So while the eviction, that lot of other people were
but
already
as of
evicted.
now, whatever may be, as on that date on which the order was passed in 2014,
Yes, Lordship.
could anybody have used that land?
In fact, no. But there's
No,
still
maybe
they are using.
If a person is there in Patta also, could that anybody have?
Cannot. They cannot. That is why there is a drive to evict all. All others were removed. They left out because of the Honorable Court's order.
Mr. Borpujari, that matter, you remember, I disposed of one matter of Mr. S.P. Roy. Matter wherein I dealt with the water bodies thing. That property cannot be touched or done anything. Nothing can be done out there.
This is one isolated case, Lordship, where the land has been allotted in water body, Lordship. But after the coming of the Act in 2000,
But the land was allotted
in 1992.
In 1992, and at that point of time when the right had accrued.
Yes, Lordship.
Yeah, there was a right which had accrued.
Lordship.
Then now the petitioner's house have been demolished.
Yes, Lordship. I fully agree.
Then how do you take care of? Now thereafter, the petitioner have not been able to construct.
No, they have constructed and they are staying there.
How can they construct now in view of the water body?
No, this is not a permanent structure. This is a temporary structure. So they are staying there because there are no other alternative land to stay. So they are staying there in some sort of bamboo structure is there. This is not a permanent structure.
But are you going to acquire it?
Yes, we are going to acquire it. But through legal means.
Then the problem can be resolved by one thing. If you can, while acquiring it, take into account the value of the property of the petitioner.
The Jirat value, Lordship, definitely can be.
No, of the building which was.
The building also will come under the Jirat.
No. As of now, there is no building.
There is no building.
So under
Lordship will indicate that, will definitely take care of that. No issues, Lordship. Lordship will, while disposing of this petition, Lordship may kindly give one observation.
No, not that observation. The stand of the government.
The government stand is very clear, Lord.
No, let the stand of the government be put on affidavit.
No difficulty, Lord.
If that is
in that case,
put, then we can very well take care of. The petitioners also think is there.
Yes.
That there was a stay by which in spite of that, it was demolished.
Lordship.
Now, if you are saying that you are going to acquire it, but also take into account the
valuation of the
property,
house.
which
My only prayer would be, Lordship.
and that will be obviously subject matter of consideration by the collector at that point of time as to what was the actual value. No, I'm not saying what they may very well submit before the authority concerned that my value was this or that. The authority can look at it. But you, at the time when
the demolition,
that property shall also be considered as a Jirat.
I fully agree. Only my prayer would be, Lordship. Lordship may keep this matter pending. Lordship will kindly direct them to implement, or on my prayer also, Lordship may implement the Deputy Commissioner, because the gentleman who is here, he is no more a part of the district admin. So for that purpose, the Deputy Commissioner's presence, and I take responsibility, so that the commitment will come through that affidavit. He cannot file that affidavit.
No, that cannot be done, because I tell you why. There are two aspects, Mr. Saikel.
Then from Lordship will direct who will file that affidavit.
No, I'm telling you why.
That solicitor Lordship will have
There's a reason why. There are two aspects. One is in a contempt jurisdiction, One is for
Lordship, no
compliance.
problem. There's the commissioner and secretary is there, the principal secretary. So I'll file that appeal.
No, why I'm saying it, in the contempt jurisdiction, as I put out there are two aspects. One is compliance and the other is punishment. For the purpose of compliance, I can very well direct any of them. But for the purpose of punishment, I have to give him a notice.
Yes. Lordship, my humble
Because what happens, there might be many cases where the incumbents keep on changing. But for the purpose of compliance, I don't need to go into all these things. The authority concerned can be very well direct.
Absolutely correct, Lordship. That is, there is no quarrel on that proposition. My only submission is that, number one, there is no willful and deliberate violation. Now the solution we have to find out regarding the loss he has suffered because of the miscommunication or whatever may be the reason. But there was no willful and deliberate violation of the honorable court's order. And I would not like to argue further because there are two orders where the interim order was said that it will continue. Then thereafter 5 years, there was no interim order also. Again, in 2019, there is an order for continuation of the interim order. So I'm not going to argue on merit also. So now only the solution regarding the compensation which can be given to them is through an affidavit from Gyanendra Dev Tripathi. He is still in the revenue department. I will file an affidavit that whatever compensation, whatever the valuation of the house in the process, the acquiring process is undertaken, then that value will be considered.
Then in that case, once you file that, you'll ask the petitioner to close it.
Yes, Lord.
That he would not like to
Lordship.
further go. So he has nothing to do with the punishment of the person. But he wants his say. During the course of hearing of the matter, Mr. D. Saikia, the learned senior counsel appearing on behalf of the respondents, submitted that the land in question falls within the ambit of the Guwahati Water Bodies bracket Preservation and Conservation bracket close Act 2008. And as such, any land which is a patta land, the government have taken a decision to acquire such lands in order to maintain the ecological balance in the city of Guwahati. He further submitted that that he would instruct Mr. T.C. Sutia, the learned counsel, in assisting him to take appropriate instruction as to whether the state government would acquire the land of the petitioner and also by taking into consideration the building which stood prior to the demolition. Taking into account the above, list the matter again on 13th of March. It is observed that in the circumstance, the government decides so, the same be put by way of an affidavit.
Highly obliged.
I in fact appear for answer number 1.
Which one?
Whether he will file or I will file.
No, I will file it through him only.
I normally call him Advocate General, but as he is appearing in the contempt matter, I call him Mr. Saikia.
Senior counsel, Lord.
I never say that.
Deeply obliged.
39 and 40.
Oh, what are these? Yes, madam. There's nobody to oppose you. Why?
But we are yet to receive our instructions.
Huh?
We are yet to receive instructions.
What is these matters about? 18/18/2013. What are these orders? We are in agreement with the views taken by the learned single judge. No appropriation of money from the contractual dues permissible unless backed by statutory provision or by express provision contained in the contract binding the part. This is a matter pertaining to none has appeared on behalf of the petitioner on call. So for the interest of justice, the matter stands adjourned to be discussed again on 6th of March 2024. It is made clear that if the petitioner is not represented on the next occasion, this court shall pass the orders on the basis of the materials.
Forty-one.
Lordship, this is your lordship. Lordship, we will serve copies to the incumbent deputy commissioner. Lordship, kindly give us 2 weeks time
For what?
to serve the copy, Lord. To serve the copy to the incumbent deputy commissioner.
I've already granted you 6 weeks. Isn't it? Don't you need to have to file? That is why I granted you 6 weeks. So that you can take steps by issuing a notice and thereupon taking up. Isn't it? Who was appearing? Miss J. Tung Po. Who is he? You? Then, sorry, state of affairs. If you don't take steps, what can this court do? Now, none of these people are there. Most likely. Isn't it? What is the direction path? Let's see.
Lordship, the writ petition is disposed of, Lordship, in page number 3, with the direction to the respondent number 2 and 5 to carry out the act of demarcating 2185 bighas of PGR land notified by the notification dated 1/12/1990 and the 15,735 bighas of land
Direction to the
notified
respondent number 2 and 5 to carry out the act of demarcating 2000. Yes,
I am representing.
here is the case where there was a direction to make a demarcation of the PGR land.
Yes.
Have you done that?
It could not be completed. It could not be completed. The order passed by this honorable court lordship is seen it at page number 14, the direction. The direction exercise was initiated by the respondent because that was a huge area. And my lord, it was found. In fact, my lord, the respondent number 1, 2, and 3 I am representing. No other respondents have been implicated so far. That is one aspect. Second, my lord, R1 and R3 have filed their affidavit. The basic stand in the affidavit is that, my lord.
I have looked into that.
Yes, it
Now
was a
tell
huge
me, have you gone for the demarcation or not?
demarcation started, but my lord, there was, my lord, objections by various local persons, and my lord, it was found that at that time when this petition was disposed of, many, my lord, government offices and my lord, buildings, including educational institutions, were already standing there on, my lord. Those things were not, my lord, brought before the honorable court, my lord, while disposing of the writ petition. Now, my lord, series of meetings were held between by the authorities along with, my lord, the representatives of the graziers, because this petition was filed by the graziers, my lord.
By the grazier.
Yes, one of the graziers. They claim themselves to be graziers, the 5 or 6 persons. With them also, my lord, lot of discussions had completed, my lord, but thereafter, my lord, nothing has moved, my lord. Now, what is the latest position, my lord? That I am not in a position to apprise.
Why?
Because I am representing only, my lord, 1, 2, and 3.
Sir, Arbor Puteri. A few minutes back, I say, compliance is the money.
Definitely. Now, if lordship
You are
directs
also the standing counsel of the revenue. He is the standing counsel of the district administration. Both of you find it out. Tell me. We are not concerned with others. Here is a case that these are great PTR land. You are therefore required to demarcate. Now you have, whether these people were party or not, that is immaterial. The question is, can, unless you, what you call the remove these lands from the PTR ambit, you can't grant any settlement or anything. And if you have done anything to our granting the government to make any construction, that is wrong. So why not carry out the demarcation?
And demarcation, we have also stated out in the affidavit that, my lord, it is mostly, my lord, a substantial part of, my lord, that land, my lord, that that land is totally unsurveyed, my lord, and substantial portion of that land, my lord, falls within, my lord, various, my lord, islands of the river Brahmaputra. And for that reason, my lord, it was very difficult, my lord. So therefore, my lord, the district administration, my lord, went to, my lord, conducted several meetings, my lord, with all the local persons, that let us find out a consensus and let us demarcate it, my lord. There were objections and counter objections. For that reason, my lord, the matter stood at one point of time.
No, but then also you are to identify the PLA. That is what you are required.
Yes.
Do it.
Well, lordship, I will have to take instructions from the department, my lord.
Have
Because
to take it.
lordship will also direct, my lord, my colleagues in the government.
Both of you take the decision as to what are the impediments for not being able to comply. Yes, this may not be a case, stricto sensu,
Yes.
for initiation of contempt proceedings.
Yes.
Because there may not be a willful violation. For the purpose of contempt, there has to be a willful violation.
Yes.
No quarrel with that.
Yes.
But the question is, there's an order being passed by this court. Unless you say this order cannot be complied with, that's a different thing. But that is not your saying.
Yes.
And the other thing is, the matter has been pending from 2015 and the judgment came on 2017. So you had enough opportunities at that point of time, isn't it?
Yes. So on field, my lord, there are substantial practical difficulties, my lord.
Understood. Those
On
practical
field.
difficulties are there. But the thing is it not possible for you to demarcate and to what you call carry out the direction?
Yes.
That is the question. If it is not possible for you to demarcate by the government, then it is a different thing. We will hold that the government of Assam doesn't have the power to even demarcate the food bank. You know, let also the people know. Only why should it be limited to food bank?
Even my lord,
The instant contempt application has been filed. Alleging willful violation of the order dated 6/1/2017 passed in deputation number 3494/2015, whereby the court had disposed of the restitution with the following directions, which is quoted here in below. It not according of day. Claim. This court has duly taken note of the affidavits which have been filed by the respondent number 1 and 3. The question arises as to whether the order passed by this court is implementable or not. Inasmuch as the perusal of the directions showed that there was a direction to demarcate the PGR lands, which have been notified by notification dated 1/12/1992, and thereupon to take appropriate actions for eviction of those persons who are not entitled to remain in the PPR lands. It is also relevant to take note of that the said notification dated 1/12/1992 has not yet been amended, have neither been amended, nor the government of Assam have denotified the such land stipulated in the notification dated 1/12/1992 as PPR land. Mr. R. Porpuzari, who is representing the respondent number 1, 2, and 3, is also the standing counsel of the Revenue and Disaster Management Department. Mr. N. Goswami, who is present in the court, is the standing counsel of the district administration. Under such circumstances, both these counsels are hereby directed to obtain instructions from the Revenue Department of the Government of Assam as well as the district administration of
it is Dhemaji.
Dhemaji
Yes.
as to why the order passed by this court on 6/1/2017, as to whether the order passed by this court dated 6/1/2017, passed in deputation number 3494 of the 2015, have been duly complied with, and if not, what are the impediments for which the order is yet to be complied, have not been complied. The matter be listed again on 27th of March 2024 for an update. Copy of the names of Mr. N. Goswami be shown in the court list.
You'll charge me a copy of it.
But
Contact with
David, you have problem? 42.
But due to lapse of time, this matter has now become critical.
Infructuous.
Yes, Lordship.
Contempt matter has become infructuous. Tell me how. It's a very serious thing. Tell me. Contempt matter, how can it be infructuous? It has must have been complied with. Complied with.
My lord, compliance will depend upon the subject to the furnishing of representation, my lord. They have not filed a representation.
Okay,
Lordship,
okay.
kindly come to page 10, my lord. Last portion, my lord.
The instant contempt application has been filed alleging willful violation to the order dated 5/3/2018 passed in WPC number 2700/2017. This court have duly taken note of the order dated 7/5/2018, wherein there was a direction to the
Respondent number 4.
direction to the petitioner to submit a fresh representation to the respondent number 4, seeking a fresh NOC within the locality. Puskar. However, the said representation having not been filed, the question of compliance with the order dated 5/3/2018 passed in WPC number 2700/2017 does not arise. Consequently, the contempt proceeding stands dropped.
Obliged.
Yes.
We are not able to contact the petitioner by the due to he is suffering brain tumor problem. So by the
Submitted.
so it's having granted for
What is the compliance sought for?
Compliance not for releasing of security money, which they have reported. That's already been released, your lordship.
You have released it.
The security money we have released, your lord.
Then what do you mean?
They are claiming that pending balance of rupees 4,01,000.
Is granted liberty to pursue the matter of releasing of the surrender with the concerned authority together with a certified copy of the order, and then shall entertain the representative if any submitted and the petitioner for release of the AR within 30 days.
That has been released.
That's
your
the
lord.
order.
That's the order released, your lord.
Huh?
That's been released.
How many orders are there? One.
one matter in page number 17, my lord.
Page number
17, 17.
17. So you've got the 63,000.
60,000 matter in para 5, my lord. May I read the
That as appears in view of the instruction in plan, as there appears to be no dispute with regard to the entitlement of the petitioner of an amount of demand, the requisition deserves to be allowed to predicting this point to release the amount of demand to the petitioner within 3 months from the date of. They
And
paid
that
that.
in that matter, I have taken instruction of fund demands have been placed, your lordship.
Huh?
Fund demands have been placed.
How much?
Fund demands regarding this compliance order of paying the remaining amount to the petitioner, your lordship. It's 4,01,000.
Have been paid.
That has been placed, but has been placed before the higher authority, your lordship, for payment, your lordship.
So not complied with.
Not complied with. Part of this compliance security deposit only released, your lordship.
That is immaterial. 4 lakhs has not been paid.
No, not yet paid.
Mr. R.R. Gogoi, appearing on behalf of the respondent, submits that the security deposit have been duly paid to the petitioner. However, as regards the direction to pay an amount of rupees 4,01,368, necessary fund demands have been made by the respondent authority, by the concerned respondents have been made, and the same is likely to be paid within
3 weeks, your lord. Within 4 weeks. 4 weeks time, we're gonna take the update.
within 4 weeks. Who's taking into account the specific stand being taken. This court fixes the matter on 23/2024. In the meantime, the respondents shall take appropriate steps for payment of the said amount of rupees 4,01,368 to the petitioner as directed by this court in its order dated 1/2/2019 passed in WPC number 7324 of 2007.
All right.
Activity under compliance, Lordship. We are paying the LA estimate.
You are paying or paid?
Paying, Lordship. Lordship may give 4 weeks time. In fact, Lordship, budget has been allocated, Lordship. Budget allocation has been done, Lordship.
Mr. N. Upadhyay, the Learned Counsel appearing on behalf of the Irrigation Department submit that the budget allocation have duly been made for an amount of
4 lakh.
rupees 4,25,467, and the same would be paid disbursed to the Deputy Commissioner, South Salmara, Mankasar, within
It may give 6 weeks time.
no, too late.
4
Within
4 weeks.
within
4 weeks.
within within 15th of March 2024. Full stop. List the matter again on 27th of March 2024, on which date the Learned Counsel for the Irrigation Department shall apprise as to whether the fund have been disbursed to the petitioner.
Obliged.
45.
Order already complied, my lord.
Compliant. The Learned Counsel appearing on behalf of the petitioner submits that the order dated held the order
11/4.
order dated 11/4/2019. 11/4 passed in WPC number 2487 of 2019 have been duly complied with. Considering the above, the instant contempt proceeding stands dropped.
My lord, in this matter, actually,
Petitioner, no, repeat.
Yes. Who is appearing for the petitioner?
My lord, I am appearing for the petition.
Oh,
My
very
lord,
well.
may kindly take the petition 47 first.
What is 47?
It is a connected petition, my lord, where the order was passed by this honorable court, my lord. This
What
is
is the
pending.
order passed?
My lord, order.
4/1/2021.
Yes, my
What order has been passed?
My lord, order was passed in IA number 1780.
No, Mr. Counsel, first and foremost, today this matter, otherwise this matter would have come up for admission. But the matter has come up for
Orders.
orders because of this contempt.
Contempt, yes.
What is this contempt business?
My lord, your lordship may kindly come to page 10.
Why contempt of proceedings? Why? Which order?
My lord, order dated, my lord, 26/6/2019.
After hearing the Learned Counsel and considering the materials of stop construction notice issued to the petitioner, state subject to the condition that shall carry out construction in terms with the permit dated demand. Then what happened?
My lord, then my lord, I am the respondent number 4 in the writ petition, my lord. After receipt of the notice from this honorable court, I have cleared, my lord, and filed IA number 1780/2019 for alteration modification of the order passed.
Where is that order?
My lord, that is annexed to search from page 10, my lord. In contempt page.
Till such time the OP petitioner shall confine her construction strictly in terms with the permission granted by Jorhat Municipal Board and make no further deviation. Yes, then?
Then, my lord, construction was continued, my lord. And with further deviation, my lord, the construction was completed.
Then?
That's my allegation. And in fact, my lord, from affidavit filed by the respondent, my lord, contender, it appears that there are some deviations. My lord. In fact, from the affidavit filed
Who
by
has granted the permission?
Jorhat Municipal Board.
Who is paying for the Jorhat Municipal? Madam, whether there is any deviation? Huh? No, have they constructed in deviation after the order passed by this court? After the order has been passed by this court, wherein first the order was passed that there should not be any deviation from the original permit. Secondly, there is again an order that they should not reconstruct anything beyond the beyond the deviation, beyond the permissible limits. So therefore, have they constructed beyond the deviation after that order passed by this court? You take your instruction.
Well, contempt is filed that we have constructed the third floor. The contempt has been filed, the allegation that we have constructed third floor. Although permission was for the basement, ground, first and second. Well, which is absolutely denied and instead
No, not denied, but the question is they have photographed.
No, they have said well, paragraph 4. Paragraph 4, well, this is the main allegation.
Construction is ground floor, first floor, second floor, third floor. Yes, there is third floor.
They say third floor. Well, it is not third floor, man.
What is that?
There is no third floor because it is the roof protection that has been given. So,
Where?
that,
Where is your affidavit?
yes, yes,
Show me with that the roof protection was permitted.
yes, yes, my lord.
Ground floor,
paragraph
first
7.
floor,
We
second
replied to
floor,
the
third
paragraph 7.
floor, fourth. Huh? Where?
Paragraph 7 of my affidavit.
No.
Ah.
Show me your permission.
Yes, fine.
The permission will be there in the writ petition.
So in the
This is the permission.
yes,
No objection certificate.
yes,
Basement, ground floor, mezzanine is not there. First floor, second floor.
Yes.
Third floor, roof protection.
yes.
Shed.
That is for water harvesting.
34.32.
Yes.
Let us see the approved plan. Where is the approved plan? Where is your approved plan?
Yes. Not. The approved plan was for it, not any, not.
You have it?
My lord, approved plan, not.
Oh, yeah. Got it. Roof protection. What is this roof protection, madam?
Roof protection, my lord, the team said, my lord, by which water harvesting is there.
Huh?
Water harvesting,
Nothing more.
nothing. And in the
Where is the third floor? Roof protection one. There is no first floor, second floor.
Yes.
Site plan, first floor, second floor.
Yes.
Is there any construction on the second floor, third floor?
No.
Okay. You inquire. No, you inquire, find out if there is any construction, demolish it, except the roof. Where?
Find out if
yes, that may be
it's
seen, my lord.
one.
The affidavit was yours, anything.
Affidavit filed by respondent number 4.
Yes, sir. No, respond number 1, my lord. Respond number yes.
Who is 4?
Yes, 2.
Affidavit filed by?
Respond number 2.
Got it. Yes. What do they say?
Annexer 1.
So one. What number 4?
The following points came up into notice during the site visit. Area of the building has been constructed more than the approved plan, which is within the compoundable limit. From rear side setbacks have been constructed, violating the norms of the approved plan, which are within compoundable limit. Front staircase from made up to front floor has been constructed without any approval, which is non-conformable. Design and height of the roof protection harvesting at the terrace is violating the approved. The approved single way slope roof has been converted to two-way slope roof with an increased height of than the approved. Okay, as per this you demolish.
My lord, your lordship, my lord, you see, my lord.
Demolish.
My lord, and in fact, your lordship may see, my lord,
No, no, if it is not done as per the inspection, this is a direct in violation of this court order. You obtain a stay before this court and then he seeks for a modification. This order had granted a stay subject to you constructing within the permit. And thereupon you construct something which is in violation as per them. Obviously demolish, but whoever is not compoundable. And even a compoundable also you have to demolish because this is in violation of this court order. Demolish.
my lord, that your lordship to consider, my lord.
No.
My lord, your lordship may see, my lord.
This is a case of Mr. Sahewala, this is a case where this is a case of imposition of huge exemplary cost upon the petitions.
No, my lord, your lordship.
No, you have taken a stay order. You are to, if you want an order passed by this court, you have taken, and this order which was passed by this court was subject to, making it very clear that you are not going to do anything. Kindly see, after hearing the parties and considering the material, stop construction is stayed. Subject to the conditions shall carry out the construction in terms with the building permit dated 1/4. This is what the specific direction. Then also you have constructed in violation. Forget about the order which he has got. But then also you have constructed which make the disnequal. The matter upon being heard and the materials being perused, a question arises as to whether post 23/2019, the petitioner had made any construction in its building which was in violation to the building permit dated 1/4/2017. The respondent, more particularly the respondent, that is the Jorhat Municipal Board, is directed to file an affidavit categorically stating as to whether there has been any violation to the building permit dated 1/4/2017. Post the stop construction notice dated 12/3/2019. Full stop. The said affidavit be filed when, madam? 15. When are you going to file this affidavit? I'm asking you to file an affidavit. The said affidavit, the said spec be brought on record by way of an affidavit to be filed by 23/2024. To sublist the matter again on 27/3/2024.
First, all prayers.
Huh?
A copy of the affidavit is supplied to me.
Oh.
Phone number 4.
Can you file it without serving a copy to the petitioner?
Respondent.
Oh, petitioner is he. Okay. The copy of the affidavit to be filed by the Jorhat Municipal Board be also supplied to the respondent number 4. Because if we find that, then because this is in violation, the question of compounding does not arise. Huh? Here is the case if there is any violation. If any violation, you demolish.
I'm obliged.
Well, this is a matter, my lord, if you also see it, Annexure 1, page 15. This is they have pledged. This is under small, my lord, enterprise act, my lord. And here they have said, my lord, because the supply was made by the
service is complete.
Hold on.
So
As far
list
as
the
one
mat-
is concerned,
we'll
my
list
lord,
the
there's
the matter has only come up for order. Some affidavit has been filed or not filed.
Filed, man.
Who
We have
has
filed
filed
An affidavit has been filed. Okay, list the matter for we'll list the matter for what you call admission.
Hello.
Okay. Please the matter for admission. When do you want?
Next week.
Next. Please the matter for admission on 26 to 2024. For,
Tonight.
Yes, what is this?
Not compliance with the order or both lordship. They appeared, lordship, but they have not yet filed any affidavit.
What is the order?
Order lordship page 14 lordship 13 14 sir. In view of the both the Lanaka, I dispose the 14 page lordship with the direction both the respondent number 5 is to conduct an inquiry in respect of the claim made by the present petition. This is only after being satisfied with the claim supported by the relevant record. Necessary order shall be passed to the claim of the petitioner. In order to conduct the inquiry, the petitioner to submit his representation along with a copy of his petition and the annex it along with a copy of his order within a period of 60 days from today. If the petitioner is entitled for the amount claimed or an amount variation thereof, after inquiry, the same shall be disbursed to the petitioner within a period of 60 days.
Mr. K.A. Mujumdar, kindly put a better copy of this order. This is not readable.
Lordship,
The learned counsel appearing on behalf of the petitioner shall file a better legible copy of the order dated 12/2/2021, passed in WPC number 7350/2019. This the matter again on 1st of April 2024. In the meantime, the respondent shall file the affidavit.
Lordship, the respondent number 2 has been transferred to another place of posting. So
You are appearing for whom?
for respondent number 1 and 2.
File your affidavit.
file affidavit or supply a better copy of the
Absolutely, file by way of an affidavit. You are asking on the basis of that.
Obliged.
Yes, my lord, as per last quarter, 11th of December, my lord, my learned friend was supposed to place inspection.
On behalf of the Doe internship, a proposal was sent by the deputy commissioner to the department. The same was remitted for such exhibit. It is submitted that such clarification has been given. Let me see the order. What order was passed?
Yes.
Page 35, my lord.
Page
35.
In the present case in hand, no such move have been initiated from the deputy commissioner in advance. Yes.
Now, yes, now, my lord, the matter is pending with the revenue department. In the meantime, I have received the latest instruction, my lord, that use of the judicial department has also been taken. But here, my lord, the difficulty is that, my lord, if lordship peruses page 36, page 36, it is a part of the order which has been, my lord, page
No. First and foremost, your basic, this letter is a letter issued on the basis of, I remember, letter has been issued by Mr. Siketa,
Yes.
as it then was,
Yes.
1991 or something.
Yes.
He says that there is a lot of things, there is a question of transfer and which is being done, which should not be done. And as such, no permission should be given by the deputy commissioner without taking the approval from the state government.
Yes.
Now, what is stopping you from granting the approval? Or don't you say that no land of the tea garden can be sold?
That is the thing. And they have taken this.
This is not a case of conversion. This is not a case of conversion. This is a case of sale.
Yes.
Without the conversion. That is a different.
So it is a case of sale. but-
Without the conversion.
Yes, without conversion. So
So can there be therefore be a permission? That is another aspect. Can you allow construction on the tea patta land?
Yes.
Which is otherwise not there. You may cancel the patta on a question of violation of the. That's another aspect of the matter. But the question is the sale of this land. Where is the question of sale being given for any other purpose? As I could see from the order,
Yes.
what they are asking, that look here, is a development agreement has been entered in between this A with the owner of the or owner of the estate, and on the basis of that, they have raised the construction.
they have raised the construction.
And therefore, now the sale cannot happen out here because of the fact the sale can happen, but the proportional share of the land cannot be given because the permission has not been granted. Now, therefore, the permission which was granted is on a different sphere. But here, it is not this document is not for sale of the land, which have been quoted.
Yeah.
This is for sale of tea garden land. But here they are using it for sale of tea garden land for another purpose, which is another aspect of the matter.
Yes, so the identity, nature and character of the land, my lord, that has been, my lord, changed, not to be changed. Because it still retains the character. of-
Therefore, you can without, you see, you are therefore asked to take a call. You have to take a call on the basis that how can you allow using this for any other land? So on that basis, you can reject it. Or you can not reject. You may be very considerate. Sometimes you are, so be considerate. And let him go to Denrela.
My lord.
Red. Against who? Builder.
No, my lord, difficulty was that, my lord, all the time, my lord, with all humility, my lordship will kindly say that direction was to the deputy commissioner. Of course, I understand. Now the content of the letter, my lord, which is reflected at page 36. Lordship, may I read it, my lord, for my satisfaction, my lord. I am directed to say that it has come to the notice of the government that some tea gardens have been alienated.
That is what I'm
Yes,
saying.
by way of without following the rules already stipulated by government letter 97. So embargo was created in the year 97 itself.
Hmm.
In some other cases, the deputy commissioner have reportedly allowed permission for transfer without referring the same to government. It has once again been informed that prior approval of the government is mandatory. In cases on receipt of any application for the alienation, the deputy commissioners are required to submit a detailed field verification report covering inter alia the following points to the government.
Mr. I have
Yes,
read
yes,
this letter. I've done the matters on this letter many times. So therefore, I know. But the question, therefore, is if they are asking for a permission for selling a particular plot of land, which is the tea patta, and making it without the change of the nomenclature by the government, can the permission be granted by the government?
So, yes. So why?
If the government cannot grant the permission without the change or declassification of that land from tea patta to any other land, so the question of permission being granted does not arise. And if the permission cannot be granted, then Mr. D. Nath appearing for the deputy commissioner is saved of all consequences.
Whole difficulty has arisen because of the my lord tenor of the language in my lord that direction. May I read it, my lord? Approval of the government. My lord, it is not that the government will consider.
Mr. Borpujari,
Yes.
how do you incorporate this letter?
It has been
I'm not.
Yeah.
This court may put it, but can you incorporate this letter out here? You can't in this fact. The fact out here is the land which have been entered into by way of an agreement for sale or agreement for development with the builder. That land is a tea patta land.
Yeah.
which have not been converted.
Converted.
If it is not being converted, there is a permission being sought for sale of a Patha land to another player.
Another. Because there is
Can
a
such permission be even granted by the deputy commissioner? No. Forget about yeah. Because that permission has to be granted by the deputy commissioner only on the basis that if it is the nomenclature is changed or the reclassification has been done. So the deputy commissioner can very well reject it on that basis. A simple thing.
But the direction was such, my lord, that in the present case in hand, no such move have been initiated by the deputy commissioner. So,
Problem arises with your counsel who is representing.
in view of
This
the
is a
stand-
case of a sale of a tea garden land.
Absolutely. I have
What was
seen-
happening at that point of time, where tea gardens were sold from one place to another. That is why nowadays you find what do you find? You find a lot of demergers. Isn't it, Mr. Bopuzari?
Yes, yes, yes.
You therefore find nowadays a lot of demergers.
Yes.
Why the demergers happen?
Yes.
Acquisition is being brought in, the land, this particular land belongs to a tea garden.
My lord.
A company is formed. The land is being taken over by way of a merger proceeding.
My lord.
Once it is being taken over, then some portion of the land is demerged out and another company is being. Now that company which is being formed is merged with the other company, and therefore the payment of court fee or sale does not arise, and by way of 391 to 94 proceedings is done.
Lordship has disposed of few writ petitions, my lord. I was here defending the state.
So this
Same
is
thing.
how it happens.
They do it in Kolkata High Court because all the companies have their offices in
This is
Kolkata.
how no, this is how the demerge. That is the reason why they do.
Yes. Now here, my lord, let alone the letter itself, this communication. There is a strict statutory embargo, my lord, under the 2015 Act itself. Reclassification. There is a process.
On the basis
On that
that
count itself, my lord,
see,
this order is not
no,
implementable. Yes, yes, yes.
considering
With
the
all
plight of the petitioner and the prospective player, the exercise of granting sale permission shall be completed within 20.
Yes.
Now the question is, can the grant be given?
My lord.
See, the exercise of granting the sale permission shall be completed. Now, the tenor of this order makes it clear that there is a direction for grant of a sale permission.
That's what.
So if you don't sell it or don't seek a review, how do you take
Yes,
note of?
that's what. Lordship will kindly accommodate me for at least 4 weeks, my lord. Yeah, I am seriously taking up the matter with the department. We had been advising them. Because this order, my lord, is a very cryptic order, my lord, with all humility, my lord. I have received instructions also, my lord, to that effect. So there is a straight bar under the statute. 2015 Act.
But one thing can be very well done by you.
My lord.
You are the government, you reject it. Then
The tenor of the order is not that.
no,
We
yes.
are in a receiving
No,
end,
no,
Lordship.
kindly see on top.
Yes.
In the present case in hand,
If that be so, my lord, I would be the most happiest person.
no, in the
Yes.
present case in hand,
Yes.
no such move has been initiated by the Deputy Commissioner of Dibrugarh.
Perfect.
Inasmuch as the affidavit of the respondent number 3 is totally silent in this regard.
My lord.
In
Yes,
that
yes.
view of the stand taken by the respondent in the affidavit in opposition and considering the pressing need of the petitioners in order to complete the sale transaction, this writ petition is disposed of with a direction to the respondent number 3, that is the Deputy Commissioner,
Yes.
to take steps as per the government circular and after obtaining the necessary approval from the government. Now, can the Deputy Commissioner impose upon the government to give me the approval? No. So the approval has to be given by the guy.
Yes.
So
And
if
then
you
up-
take,
Yes.
if you obtain, you reject the approval on the ground that you cannot, without declassification, you cannot. Then in that regard, he cannot comply.
No, he will- Yes, he cannot
Then
comply.
where is the willful violation?
Yes.
My lord, there is another way, my lord, which says, my lord, if the condition of tea plantation is not there, then it can be converted.
What?
If the condition of tea, my lord, special cultivation of tea is not there,
But has it been converted?
no, it is already, yes, my lord.
No, it
Has
is
the
not
land been converted?
No.
So earlier it was Jalan Charity Trust land method. Then Jalan Charity Trust, they sold to the petitioner. You way back in 2002, 2003. Now, my lord, these petitioners, when they sign and develop an agreement with the builder, my lord, now the problem has started. Already the deputy commissioner.
Understood, but
Yes.
sale made, it still continues to be a tea patta.
Tea patta.
If it is a tea patta out there, how can you allow any construction or do anything out there apart from what is required? Otherwise, this will go, that land will go under the section 5 of the Assam Fixation of Land Ceiling Act.
And yes, sir, that's correct, my lord. And it's not only me, my lord.
Because you are using that particular plot of land for other purposes, which are not even ancillary to the cultivation.
Now the 2015 Act, I was just going from my lord, if lordship permits me.
Which one?
2015, my lord, Assam Agricultural Land Regulation of Reclassification. So that is clear, my lord, section 4 and 5. Section 4 says, my lord, 4.1, such land which is recorded as agricultural land but has already become unfit for agricultural purposes or where there has been no agricultural activity for last 10 years preceding the date of application for permission shall only be reclassified or reclassified come transferred for intending non-agricultural purposes with the prior approval of the deputy commissioner. That is one. 2 says no agricultural land under cultivation during 5 years preceding the date of application for permission as required under so and so shall be reclassified or classified and sale without prior approval of the state government in the revenue department. Then, my lord, 5 says procedure for land, my lord, reclassification. Any owner of agricultural land who intends to reclassify or reclassify come transfer agricultural land shall make an application to the deputy commissioner under whose jurisdiction. So this is a condition precedent, which lordship has rightly pointed out. So therefore, first I will have to convert it. Then only I can put it to sale. That's all. So this is a statutory embargo. Therefore, my lord, I am respectfully submitting, let alone this, my lord, 2001 government circular. Is a, my lord, embargo created under the statute itself.
When was this act passed?
This order was passed in the year 4/8/2021. Lordship is absolutely correct. These aspects of the matters were not brought into the knowledge of this court.
No, but then also I think you take up the decision, take a decision.
Yes.
Once you take up a decision on these aspects, then the deputy commissioner is safe. Then it may be a case of the petitioner have to file a separate petition if they have to state. Because you see, I have not gone into the 2015 Act. But if you see the tenor of the 1936 Act,
Yes, 36 says is a genesis. 36 Act says, my lord, that
it is the same thing.
Yes, same thing.
36 Act says, and the reason why it has been said how you have to make it industrial, what is there? The assessment, reassessment Act of
Lordship had dealt with section 20 sometime before
Yeah.
that, my lord, big clean case. That rupees 10,000 lump sum amount, my lord. That matter. Lordship was dealing with it, my lord. 36 Act is the genesis. There, my lord,
related 36.
yeah, related to
In fact, the
36.
same.
Yeah.
Because this is how there was a lot of move being made at that point of time to make it.
Absolutely.
And therefore, there was a lot of FIRs also being filed.
Yeah.
On the basis that there was an affidavit being filed that I am not going to sell off this land. What were being done at that point of time was this. There was a sale being made and the person who was going to purchase, he was saying, he used to say on affidavit that I am not going to use for any other purpose other than agriculture. And that is one of the grounds for selling. And therefore, later on, the government started filing a lot of FIRs against this falsification of the.
Yes, yes. Because all the, my lord, it was a big game for the revenue staffs all around the state of Assam. I could not spell it out.
No, I think you should pass appropriate orders.
Yes,
now.
yes, yes.
Once you pass an order, then the deputy commissioner can very well come up and take a stand to that effect. That because if you don't give the permission, what is the Mr. Nath going to do?
The problem is not it's not three, my lord. TC has given us the permission to purchase the land, my lord.
Understood, but Mr. Counsel, if you see that particular affidavit which you have filed, you see the permissions are given with an affidavit. in respect to agricultural land, you always say out that I will maintain it as an agricultural, but I won't use it for any other purpose.
Yeah.
That is a mandatory for sale of an agricultural land. You may not have taken similar matters earlier in those type of matters. Because an issue arose because there were many lands which were being taken over. This happened sometime in 2015, 16 or something. And that is why this 2015 Act came in.
15 Act has
Because this was codified. This one.
Yes.
Because the state government was having a lot of problems. There were a lot of bail applications being filed. State government was having a lot of. But for sale, he has to mention. But anyway, whether it is done or not, the deputy commissioner has told it, but you can't use it for any other purpose if it is a keeper. Except use it only for keeper.
That is what the circular says. If it is otherwise not stable.
Because what will happen is the 1956 Act and the rules framed there under 1957. It says that this Act of 1956 does not apply to Tika, or the the words used is special cultivation.
Yes, special cultivation.
Now, Section 5 stipulate, or Rule 5 categorically stipulate that in what circumstances certain lands from the tea garden can be taken. If it does not come within the ambit of the lands which can be kept for special cultivation, there is certain lands can be kept for future cultivation. And that is why a lot of lands are there which are not being used. In fact, your land happens to be one. Anyway, I think we adjourn this matter for 4 weeks. In the meantime, I did not further more.
I'm so obliged, my lord, but because
You need to do something.
yes, 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 because we were, my lord, perturbed by this word, my lord, after obtaining necessary approval. So we thought that, my lord, if it is a positive direction, that you have to approve.
No, but the direction from whom? To whom? The deputy commissioner.
No, from the government.
From the government.
Understood.
Yes.
The direction is to the deputy commissioner to obtain the permission from the government.
Yes. After approval, after obtaining necessary approval from the government.
So that means the
we
permission,
thought
the
that-
direction is to the deputy commissioner to take the permission from you.
Permission from the government.
No, if you don't give, then how the deputy commissioner has a will to file?
I am obliged, I am obliged.
Okay, list the matter again on first, the matter upon being heard at length, this court heard at length, list the matter again on 1st of April 2024 for a further update as regards the status of compliance with the order dated 4/8/2021, passed in WPC number 2789 of 2000.
Only one pilot request, my lord, with all humility, lordship, may kindly keep his part.
No, not necessary. Let me see. I am not giving.
I am obliged, sir.
The Lawazima order, sir.
Huh?
Service. The Lawazima order 5/2/2024.
Yes, service complete.
Service, it says service complete.
Okay. Service being complete, list the matter. Oh, yes, then what happened?
But no one has appeared.
Huh?
No one has appeared to deem such court.
He must not have appeared because you have not used a tree or anything. Huh?
Well, that's a mistake.
Let me find out. Here. Mr. Dinath, you are also the PWD.
Yes.
What has happened? This is a contempt proceedings against the various officials of the PWD. They are not represented and the service is duly complete. I think you need to take it up with this official. Otherwise, it would be.
I'll take.
Mr. Dina, the learned senior government and the learned standing counsel for the
PWD. Sanjeev Shyam is the chief engineer of PWD roads.
standing counsel for the PWD department submits that he shall take necessary steps for apprising the respondent numbers 1, 2, and 3 about the instant proceedings. List the matter again on when do you want it? Because you are going to appear. When do you want it?
But, Lordship, may keep after 2 weeks. I'll get the instruction by that.
On 6th of March?
Apply.
Because here the direction was to follow Tamsir.
Okay, so
So
what is the
just
position?
find it
I'll-
out whether do you the
Look.
verification and thereafter to keep it well.
Yeah.
Yes.
But in item 52, I may
taken step.
Huh?
Taken step.
I have filed the wakalatnama for respondent number 3, Malad. And I have information for the respondent number 1 and 2 also. But
These are the people who are there in that matter.
in the that's why.
So what do you want?
But here respondent number 3, Malad, he retired long back before the order is passed. He retired on 31/1/2022. And the order of the honorable court is, Malad,
Respondent number 3.
respondent number 3.
It has been brought to the attention of this court by Mr. Dinath, the learned counsel appearing on behalf of the respondent number 3,
Yes,
that the said respondent number 3 had retired on
31/1/22.
31/1/2022.
Two.
And the judgment wherein the petitioner has sought compliance is dated 28/3/2023.
23.
Taking into account the above, the name of the respondent number 3 is struck off.
We have also filed an affidavit to that effect.
Hmm?
An affidavit has been filed to that effect. I have served in the
It's struck off.
No.
The full stop. Mr. Dinath appearing on behalf of the respondent number 1, 2, and 4 shall praise for an accommodation for obtaining instruction and filing affidavit if need be. To list the matter again on 18th of March 2024.
Pertaining to the respondent number, it may be allowed to
Why do you need it? Because he is not you are already having one.
In fact,
Who is number 4? Show me who is number 4.
Golagat 3 is Golagat State Road Executive Engineer, Golagat State Road Division, and 4 is Bokagat State.
Mr. Counsel, let us have it on the 18th. As of now, don't do it.
Yes.
Your basic thing is non-payment of dues. Huh? We'll look into it. Let him come up because the chief engineer and all these things are there.
Yes.
See one because now if I do it, I have to give you another 6 weeks. Whereby it will be in your not in your interest.
Yes.
respondent number 4 is also not there. He's also
Huh?
respondent number 4 is also not there. He was transferred long back.
When?
But
But he was there after the order was.
Yes.
I'll
Yes.
get the
You
order.
bring it on
I'll get
record.
the-
whatever.
I'll get the order. But Lordship, for 1 and 2, I'll get.
You see, it is a question of non-payment. You just say as to whether you have must be the direction must be given as regard Tamsir Ali. There's nothing else. So Tamsir Ali as to whether you have considered and whether they are lying out there. What is the state?
Yes.
That's all.
I'll get it.
Well, further
In fact, if these type of matters needs to be completed on the first or second day itself,
I'll get
keeping it
Get
pending
it.
out there this way, because you will only pay when you have the fund. Yes. What is this item number? 53. Yes.
Notice with respect of my lord, 1 and order number 1 and 3, my lord, came to this house, my lord, but 3, my lord. it is
1
that-
to 80 and MBS purported instance to ensure communication you have to date, neither the 80 card nor the answer of the response number 3 is present.
96 is 39, but
Yeah, 39. Okay.
39,
Service upon the response number 3 being not complete, list the matter after completion of service.
wait, my lord, they have got notice, my lord.
Huh?
It was a consent order, my lord, in the writ petition, it was a consent order, and they have paid some amount, my lord, some amount.
Very well. But then also service is
54.
not complete against response number 3.
But he is appearing, my lord, he put the Pakistan.
But this is different.
Yes,
Huh?
yes, that is correct.
Yes, madam.
Public.
Other direction number 4, that is water resource department, permit me to implement matter. Response number 4 posted to the respect, as the Secretary of Government of Assam Congress Department.
What is the order passed?
Order passed matter 15/5/2022 in case number 5.
In the counter FTTP system is yeah. The evidence that the proceedings on the year did not result in an award under section 11 of the followed by
Page 196.
water resource?
And for the response for 1 year.
Yes, what do you have to say?
As per a letter received by my office here on 8th of February, annexing the Paragraph comment, amount has been ascertained. And what it is also said it's on the payment of awarded amount is under process. Amount has been ascertained, final award, which needs to be paid to the petitioner here.
How much?
If petition number 1,
3 crores.
it's about 3 crores 6 lakhs.
3 crores 24 lakh
Yes,
85,758.
Yes,
This has been done by the response number 3.
Yes,
Now, water resource is sitting over it.
Yes, Your Lord. I think they have not served, Your Lordship, as per the office.
Office notes are not served. Notice of has been received back as unserved without any demand. To date, neither the AD cards of 2 and 5 has been. The service upon the response number 2, 4, and 5 being not complete.
I'm fine.
What is 5? Who is 5?
Ready.
Huh? And the service upon the respondent numbers 2 and 4, 2 and 3. No, 2 and 4 being not complete. List the matter after completion of service of the said respondent. In the meantime, the other respondents shall file the affidavits.
Your Lordship goes through the record. I think response number 3 has filed an affidavit directly to the.
But that is not an affidavit.
Yes,
They
Your
have
Lordship.
given it to the government advocate. The
Yes,
government
Your Lordship.
advocate
That has been
should
placed on the record, Your Lordship. Oblige, Your Lordship.
Yes, what is this?
Notice the writ petition was disposed of on the basis of submission made by the Council of
Huh?
which was actually incorrect.
What?
Your Lordship, in this case, what happened, Your Lordship? A award was passed by the MSCT in favor of the claimant.
That means that the balance now payable to the petitioner is 45, which shall be released to the petitioner on or before him. Taking into account the state of petition, the court therefore disposes of the director responsible to ensure that the state amount is released on or before. Yes, then what?
Your Lordship, this direction, this submission made by the AST committee was actually incorrect. In view of the fact that 2,92,000 was still payable, the submission was actually incorrect, and along with interest, he said only 40,000 is payable. Your Lordship may kindly see the certificate at, your Lordship, MSCT award was not paid. A certificate was issued to TC to realize as,
Page.
page 15, Lordship.
Page
Actual page 16, your Lordship.
17.
17, your Lordship, cancel log. I request you to recover an amount of 8,38,000 itna with interest at the rate of 6%.
Where?
Is lower part, last.
Oh, that one.
They paid only 5 lakh something and submitted that they have paid.
The Mr. B.K. Jain, the learned counsel, this court having perused the materials on record and taking into account the submissions to made, issues notice upon the respondent number 1, 2, and 3. Opposite party number 1, 2, and 3. The petitioner shall take steps by way of register as well as usual.
I'm for 1 and 2 now.
Issued notice. Issues notice.
ASTC council is here, your Lord. I may serve a copy of.
No, I'm not praying.
No, you are not there. The JRO is pending.
Issues notice making it returnable on 23/2024. The petitioner, Mr. N. Goswami, accepts notice on behalf of the respondent number 1 and 2. The petitioner is given the liberty to take steps upon the standing counsel of the ASTC within, by, on or before the standing counsel upon the of the ASTC. The said steps be taken. Now the extra copies of the review application be served upon Mr. N. Goswami and the standing counsel of the ASTC on or before 19th of February 2024. This recording. Your last name? Yes, what is this?
Look, I for condemnation of failure also condemning 577 days Lordship in filing substitution petition.
Hello, let this matter come up next. Or should I dispose it? Substitution of the legal aid of respondent number 3.
3, Lord.
Why it's so delay?
Lordship. Earlier, I was filed for petitioner was that Lordship. That time I have filed I for condemnation of failure.
Understood. Why so much of delay?
Lordship. I have come to knowledge, Lordship.
Okay, we'll have it next week. Online. This is the matter again. Who is appearing for the respondent? Did this matter come up before this court earlier, madam?
Earlier, Lord.
Huh? All these type of applications are not required. You are in a writ proceeding. Anyway, this is the matter again on 21st February 2015.